Muhammad Inayatullah, paragraph 11 I referred. I think they can display it in the, show the judgment in the display board. They will, I spoke to them. Yes, paragraph, Lordship can go to paragraph 11.
No, just a moment. You had given a note.
Yes, I prepared a note as well as the list of decisions.
It's a list of citations. Now, come to consider.
I can supply it again, Lordship. There's no.
No.
Lost it.
Supplying is not an issue.
Might have written something. Yes. It will be there in the page. It's a 3-page.
Because of
Lordship,
I have a bad habit of not being able to connect without my own handwriting.
cannot be said to be a bad habit.
Huh?
It's a good habit.
If I see my handwriting, I can recollect almost 90% of it, what is transpired. But
Yes.
without my own handwriting, very difficult to come back again.
Lordship deals with so many cases, not possible.
Yes, please come back to Inayatullah again.
Yes. Paragraph 11. Or Lordship is referring to some other paragraph.
No, that proposition of distinctly related.
Yes. In fact, the statement Lordship will get in the middle part of that paragraph.
This Inayatullah citation was which one?
This is citation 76, 1 SSC 828.
70?
6, 1 SSC 828.
Yes, para 11.
Yes, paragraph 11.
Yes.
To shorten the time, the first few lines may not be required.
Oh, now I remember where that note has gone. Yes.
In fact, first Lordship will wait for the note.
Mr. Goswami, Mr. Saiwala, this will continue till 12 o'clock. So you can come after that. This bench will continue till.
Which measures will be taken up? Where measures?
No, that was inevitable. There was honorable. No, I understand. We are sorry, but last moment there were movement. We could not have avoided. So since this bench will be there till 12 o'clock, so post 12 you can come. I don't want seniors to sit. That's why. Yes.
In fact, first few lines, Lordship can skip. The relevant would be the word distinctly means directly. Lordship got it?
Yes.
The middle part of that paragraph, the word distinctly means directly, indisputably, strictly, unmistakably. The word has been advised, used to limit and define the scope of the provable information. The phrase distinctly relates to the fact thereby discovered. There's some mistake, is the linchpin of the provision. The phrase refers to, I think this line will be most important. This phrase refers to that part of the information supplied by the accused, which is the direct and immediate cause of the recovery. This is what distinctly related would be. What information he has supplied, and that part only will be relevant, which is direct and immediate cause of the discovery. They have discovered it on the day itself, and he stated the statement on that day itself just before the recovery. So that is distinctly related. And the next line also, the reason behind this partial lifting of the ban against confession and statement made to the police is that if a fact is actually discovered in consequence of information given by the accused, it affords some guarantee of truth of that part, and that part only of the information which was clear, immediate and proximate cause of the death. It should not be like he has said today and thing is discovered after 3-4 days. It should be proximate. It should be an indirect connection. This is what Inayatullah says. Then the next judgment, Lordship will see Rajiv Fukon's case. Why I'm referring is, although in the Supreme Court case, I have referred that the writing of the discovery statement is not mandatory, if I can show from the evidence. But in this High Court judgment of full bench, here it is said prudence requires that it should be written. This is what 2009 to GLT 414. This is Rajiv Fukon's case, the other case, Rajiv Fukon's case, same thing, same the email, you'll get it. Rajiv Fukan versus State of Assam. Yes, their Lordship will go to paragraph 27. 27. 27, it talks of what needs to be noted that in case of judicial confession, what an accused might have stated before a magistrate is proven by the written record. In the case of extra, the Lordship will skip that part for paucity of time. Lordship will go to, however, the probative value of Lordship will go to that, a disclosure statement. Lordship found it, a disclosure statement at the bottom, 10 lines from the bottom.
Yes.
A disclosure statement is not, as noticed above, statutorily required to be reduced into writing. But prudence demands that when a statement has been made by the accused person while in the custody of a police officer and the investigating officer intends to act upon the statement, then the investigating officer should record at least that part of the statement which is likely to lead to the discovery of a fact, so that a contemporaneous record remains available to prove that statement. So requirement is a prudence requires. This is what our High Court has said. But little before this, I have placed a judgment of Muhammad Arif versus State of NCT, which is written in my note. There it is said that it can be proved in absence of discovery statement. So as far as 27, I'm ending the judgments on this subject. Then, Lordship, I'll go to that judgment where it is said, in absence of DNA profiling. This is Sunil. Sunil versus Lordship. The next case is Sunil versus State of Madhya Pradesh. This I'm referring for the purpose that in absence of DNA profiling, because in our case, they could not do it. Other evidence, if established, would suffice. Only to that extent, I need not give any judgments to that, but then still one paragraph, paragraph 3 of Sunil. Paragraph 3, it's a small paragraph, Lordship can see, from the provisions of section 53A of the code and the decision of this court in Krishan Kumar. This I have seen, but this is more better, I found. It does not follow that failure to conduct the DNA test of the samples taken from the accused or prove the report of DNA profiling as in the present case would necessarily result in failure. Yes, as in present case would necessarily result in failure of prosecution case. As held in Kishan Kumar, section 53A really facilitates the prosecution to prove its case. A positive result of DNA test would constitute clinching evidence against the accused. If, however, the result of test is in the negative, that is favoring on the accused, or if DNA profiling had not been done in a given case, the weight of the other materials and evidence on record still have to be considered. It is to the other materials brought on record by the prosecution that we may turn to. So other evidences are, in my humble opinion, the chain makes out a chain. So DNA profiling could not be done, that will not be fatal. Then the next case, Lordship was saying on the other day that by consent, still blood samples can be taken by the accused. That is Selvi's case, Lordship knows. It's a very long judgment. I'll just place one paragraph. Selvi versus State of Karnataka. This is last paragraph 223. Last paragraph of this. 223. 223. There, Lordship will see, after discussing the entire aspect on this, in the light of these conclusions, we hold that no individual should be forcibly subjected to any of the techniques in question, whether in the context of investigation in criminal case or otherwise. Doing so would amount to an unwarranted intrusion into his personal liberty. However, we do leave room for voluntary administration of the impugned techniques in the context of the criminal justice, provided that certain safeguards are in place. Even when the subject has given consent to undergo any of these tests, the test results by itself cannot be admitted as evidence because the subject does not exercise a conscious control over the responses during the administration of the test. However, any information or material that is subsequently discovered with the help of the voluntary administered test results can be admitted in accordance with Section 27 of the Evidence Act. So although although it is said by safeguards, it can be taken and it will be ultimately used in the manner Section 27 is used. Because, and that shows that it will be only a link in the circumstance. Section 27 cannot be the only ground for conviction. If we applied a similar analogy here, so it will be only a link in the circumstance.
But this decision of Selvi is limited to this narco-analytic test, polygraph, and brain
detector.
electrical activation profile.
But no, that blood, that part was also taken. The collection of blood sample was also dealt with. that I'll place the paragraph, Lordship. Selvi, although main was a lie detector, but this blood Lordship will get it at paragraph 135 also, where they have referred to blood collection as in America. 37, a blood sample was taken against us with the direction of a police officer. So the collection of blood was also dealt with in the same
135.
the 137, 135 in respect of America. Then so many 139 also.
Just one will come to
Lordship.
Oh, the same.
I'll refer to those paragraphs. I'll take back the note. I'll again refer to that paragraph. Sample of his blood, urine, everything was dealt with. I'll write these paragraphs in.
No, it's okay. 139.
Yes, 139.
Huh.
139 is that Law Commission's report. Then 143. Kathi Kalu Ogat was referred to.
No, this blood sample. Where is the reference to blood sample?
43, Lordship will see.
Huh.
We were alerted to some High Court decision. We have relied on CAT to approve taking of physical evidence such as blood and hair samples in the course of investigation. Then they have referred to 53A, where examination includes blood examination. Then
come down.
Lordship will see paragraph 53,
no,
153.
Up. No,
it was held in Jamshed's case.
Down. Yes.
Lordship will see 153. They have referred to Jamshed case, wherein it was held that blood sample can be compulsorily extracted during a medical examination conducted under 53. But at that time, collection of blood sample was not expressly contemplated in the said provision. 53A had not come by then.
CRPC. Because this amendment came in 2005.
Yes. 53A.
Provision to question করা নাই 15 আছে স্ট্যাটিউট কিন্তু এটা নন ওয়ার্কিং সুপ্রিম কোর্ট করেছে মানে কইলে তো স্ট্যাটিউট ইন্টারফারেন্স হবে না স্ট্যাটিউট ইজ देयर इन द बुक बट नॉट एनफोर्सेबल
$175 again. Lordship will go to 175. Here, paragraphs will not tally with your Lordship software, I think. 175, the case that they have referred, Anil Anantro Lokhande, there it is said, once it is held that section 53 of CRPC does confer a right upon the investigating machinery to get the arrested persons medically examined by the medical practitioner, an expression used in section 53 includes in its import the taking of sample of blood for analysis, then obviously the said provision is not violative of the guarantee incorporated in Article 21 of the Constitution of India. This line of precedent shows that compelled extraction of blood samples in the course of medical examination does not amount to conduct that shocks the conscience. There is also an endorsement of the view that use of force, as may be reasonably necessary, is mandated by law, and hence it meets the threshold of procedure established by law. In this slide, we must restate two crucial considerations that are relevant for the case before us. Firstly, the restriction placed on personal liberty in course of administering the impugned techniques are not limited to physical confinement and extraction of bodily substance. All the three techniques in question also involves testimonial responses. Secondly, most of the above cases were decided in accordance with the threshold of procedure established by law or for restraining personal liberty. However, in this case, we might use a broader standard of reasonableness to evaluate the validity of techniques in question. This wider inquiry calls for deciding whether they are compatible with the various judicially recognized dimensions of personal liberty, such as right to privacy, the right against so-and-so. Then they go to right to privacy. Then finally, 205. Now, it's undeniable that during narco analysis, this will not be again. But they have referred, and lastly, that was the conclusion.
You see, in this case, I think what is happening is when narco analysis test, DEAP, those tests are being referred to, a parallel was drawn that under 53A, you could take blood samples and therefore that could be applicable. The Supreme Court says no. This judgment, you see, in this case, Selvi, the issue of collection of blood sample was not even an issue there.
Not even an issue there, yes.
So therefore, it was merely drawing of a parallel that since 53A provides for that, and therefore doing so for narco analysis there would not infringe Article 20 Clause 3.
So same analogy will be applicable.
No, Supreme Court says no.
No.
The narco analysis test, these are, you see, these are not voluntary statements. These are the reading which is done by using of scientific techniques.
Yes.
So that cannot be an evidence when he does not volunteer for that. That's what the in some substances judgment is.
So as far as collection of blood, that will not.
Blood was not the issue in this decision.
And without the consent.
There's a express law. Because otherwise, you see, if there is it's only I think, because this I have not read so thoroughly. You see, when there is a provision of law, the provision of law by a judicial pronouncement can't be made odious. It was not struck down. Otherwise, the Supreme Court would have struck down the law.
Yes.
That was not done.
That was not done.
So
perhaps that Jamshed case is the.
Jamshed is again prior to 2005.
To
it only refers to Jamshed only refers to 53, not 53A.
No, had not come by then.
It was not there by then.
So as far as that collection of blood, I'll place another judgment on the next day. So let me skip over that. Then Lordship will go to the next case, that is on actually I could have referred to Modi's jurisprudence in order to show the vulva and labia majora was found swollen and there were injuries. In order to show that, I have placed one judgment instead of showing Modi. Same they have referred. This is 2009 6 SSC 635 Satyapal. Satyapal judgment is on that. Lord Satyapal versus State of Haryana. that Lordship will go to paragraph 16. In Modi's medical jurisprudence 23rd edition at page number so and so, it is stated, to constitute the offense of rape, it is not necessary that Lordship is writing it. At page 897, it is referred to in Modi's jurisprudence. To constitute the offense of rape, it is not necessary that there will be
what was the
complete
citation?
penetration. This is 2009 6 SCC 635.
2009?
6 SCC 635, paragraph 16. It is
Yes.
said that complete penetration is not required. Partial penetration of the penis with the labia majora or vulva without emission. Here though we have found semen, but even injury in the labia majora is enough to bring home the guilt under the section of rape. This is what Modi's jurisprudence says in paragraph 16. It is therefore quite possible to commit legally the offense of rape without producing any injury to these genitals or leaving any seminal stains. So here in our case, the labia majora was found swollen. Because of this, I'm referring to paragraph 16. Thereafter, the next decision would be, my learned friend said that the FIR needs to be sent within 24 hours. That I found one judgment saying that it needs to be sent forthwith. There is no statutory requirement that it needs to be sent in 24 hours. This is Chatkau versus State of Uttar Pradesh. Chatkau versus State of Uttar Pradesh. This is referred to 2023 6 SCC 742. Paragraph 62.
Please give the citation again.
2023 6 SCC 742. Paragraph 62, 64. 62, Lordship will see. Paragraph 62.
What is the name of the parties?
Name of the parties is Chatkau, CHOTKAU. Chatkau versus State of Uttar Pradesh. Paragraph 62 reads as such. Section 157(1) of the code requires the officer in charge of the police station to send the FIR forthwith. The legal consequences of the delay on the part of the police in forwarding the FIR to the court was considered by this court in Braham Swarup and another versus State of Uttar Pradesh, 2011 6 SCC. Incidentally, Braham Swarup is also a case where there was a delay of 5 days in sending the report to the magistrate. After taking note of the several earlier decisions of this court, Swarup is follows. In the instant case, the defense did not put any question to disregard to the investigating officer. Thus, no explanation was required to be furnished by him on this issue. Same is the case at our hand. Thus, the prosecution had not been asked to explain the delay in sending the special report. Now that question has been raised, but not at that time. More so, the submission made by Tulsi that the FIR was anti-time cannot be accepted in view of the evidence available on record, which shows that the FIR has been lodged promptly within 20 minutes of the incident, as the police station was only 1 kilometer. Then Lordship will go to section 64, paragraph 64, why it is done. State of Rajasthan versus Court Braham Swarup, this is the finding. The purpose of forthwith communication of a copy of the FIR to the magistrate is to check possibility of manipulation. Therefore, a delay in transmitting the special report to the magistrate is linked to the lodging of the FIR. If there is no delay in lodging of an FIR, any delay in communicating the special report to the magistrate would really be of little consequence, since manipulation of the FIR would then get ruled out. Nevertheless, the prosecution should explain the delay in transmitting the special report to the magistrate. However, if no question is put to the investigating officer concerning the delay, the prosecution is under no obligation to give any explanation. There is no universal rule that wherever there is some delay in sending FIR to magistrate, the prosecution version becomes unreliable. In other words, facts and circumstances of the case are important for a decision in this regard. So to that, I'm showing this judgment. Next
What was the previous paragraph prior to
paragraph
64?
62 and 64.
62 and 64.
I've written it in my note. 62, 64. Check out. It's in serial number 11.
11.
In fact, I have to take that back because one judgment I've added on non-examination of the person who has given information, GD entry. On that, I've brought one decision. And next judgment I would like to show is on non-examination of independent witness is always not fatal. Of course, this is a subtle position of law. Only one paragraph I'll show from AIR 1988 SC 696. This is Appa Bhai. Appa Bhai is in a different mail. I think Appa Bhai is in a different mail. That is where Muhammad Noshad is there. Same 25th September. Appa Bhai. This is 1988 SC. I couldn't get it in the SCC, the citation. AIR 1988 SC 696. Because all other judgments are on NDPS, where independent witnesses could not be gathered. Here it is a case which is not on NDPS, so I brought this. Paragraph 10. Appa Bhai is paragraph 10. In the light of the principles, we may now consider the first contention urged by the learned counsel for the appellants. The contention relates to failure of a prosecution to examine independent witnesses. The High Court has examined this contention and did not find any infirmity in the investigation. It is no doubt true that the prosecution had not been able to produce any independent witness to the incident that took place at the Bastard. There must have been several of such witnesses, but the prosecution case could not be thrown out or doubted on the ground alone. Experience reminds us that civilized society, civilized people are generally insensitive when a crime is committed. Even in their presence, they withdraw from the victim and the vigilante. They keep themselves away from the court unless it is inevitable. They think that crime like civil dispute is between two individual or parties and they should not involve themselves. This kind of apathy of the general public is indeed unfortunate, but it is there everywhere, whether in village life, towns or cities. One cannot ignore this handicap with which the investigating agency has to discharge its duties. The court, therefore, instead of doubting the prosecution case for want of independent witness, must consider the broad spectrum of prosecution version and then search for the nugget of truth with due regard to possible probability, if any, suggested by the accused. The court, however, must bear in mind that witnesses to a serious crime may not react in a normal manner, nor do they react uniformly. The horror-stricken witness at a dastardly crime or an act of egregious nature may react differently. Their cause of conduct may not be of ordinary type in the normal circumstance. The court therefore cannot reject the evidence merely because they have behaved or reacted in an unusual manner. Then Lordship will not required to read the further part because the way the witnesses behave, this is what is stated. So the fact remains, independent witnesses, even if they are not there, that will not be fatal to the prosecution case, if other evidences are there on record. Then, Your Lordship, I would like to place, Lordship, this is Appa Bhai, 88 SC 696, paragraph 10. Then the next judgment is on how far a GD entry will be considered as an FIR. How far a GD entry will be considered as an FIR? This is Yanab Sheikh versus State of West Bengal. This is 2013 6 SCC 428. There, Lordship will go to paragraph 8 and 9. In fact, I have referred to 5 to 9. 5, where the Honorable Supreme Court said that now I will deal with the question whether 5, Lordship will see the first line. First and foremost, we may now examine the question whether Exhibit 1 can be treated by the courts as the first information report. And if so, what is the effect of that exhibit in view of the present? That exhibit was GD entry.
This is 2013 6 SEC.
To 13-6 SEC 428.
Yanab Sheikh.
Now, I've given that mail. Yanab Sheikh versus State of West Bengal. Paragraph 5, the first line, because they are dealing with the facts of that case after that. Paragraph 5, first line, Lordship will see they have started with the discussion as to when this GD entry will be the first information report. And then they go into the facts, and Lordship, I need not bother your Lordship with that. Then Lordship will go to paragraph 8 and 9. Because here what happened, there was a fight over taking water from a tank. And that fight resulted in killing one of the person by a gunshot. So in that respect, one of the villager went and informed the police. Or he called up the police that there has been a fight and somebody died. In that context, that reference is made. And paragraph 8, Lordship will see, in case of Manu Sharma, 2010-6, a bench of this court took the view that cryptic telephone messages could not be treated as FIR, as their object is only to get the police to the scene of offense and not to register the FIR. The said intention can also be clearly called out from the bare reading of section 154 of the code, which states that the information, if given orally, should be reduced to writing, read over to the informant, signed by the informant, and a copy of the same be given to him free of cost. It has not been done in case of GD entries. GD entries are barely considered an FIR when all the informations are there, and lot of investigation proceeds on that. In our case, Lordship had seen that GD entry was only to the extent that she had died, but one stipulation is there, she was killed by unknown miscreant. He will not know because there was no there was no eyewitnesses to say somebody's name. This has come when people have gathered near the body. Yes, I've seen him going. Somebody said, yes, I've seen him going out. When all those facts came into picture, then only his name was revealed. So here is not a case where every information was there in the GD entry, and one cannot say who had actually killed when he had given that information. That information was given immediately after the incident. Not possible for anyone to name the culprit. So it was written, unknown miscreants have killed that person, and the only purpose is to get police to the place of offense. So in that context, GD entry, in my humble submission, in this particular case, will not be an FIR. Then Lordship will go to the quoted portion of Andhra Pradesh Pandurunga. Certain facts have been rightly noted by the High Court, where the information is only one which requires the police to move to the place of occurrence, and as a matter of fact, yes. Gotcha. The quoted portion I was reading. Certain facts have been rightly noted. I'm going little fast, I think, because in order to finish the matter. Certain facts have been rightly noted by the High Court, where the information is only one which required the police to move to the place of occurrence. And as a matter of fact, the detailed statement was recorded after going to the place of occurrence. Same thing had happened here. The said statement is to be treated as FIR. But when some cryptic anonymous oral message which did not specify a cognizable offense cannot be treated as an FIR, the mere fact that the information was first in point of time does not by itself clothe it with character of FIR. The matter has to be considered in the background of section 154 and 162. A cryptic telephonic message of a cognizable offense received by the police officer would not constitute an FIR. Because in some judgments I have seen, if any cognizable offense is informed, that will be an FIR. But here it is made clear, a cryptic information of a cognizable offense also will not be treated as an FIR unless there are details. Paragraph 9, Lordship will see. The purpose of telephone call by PW6, where admittedly he gave no details, leading to recording of the entry would not constitute FIR as contemplated under 154. The reliance was placed on so-and-so. Even in so-and-so case, another bench of this court, we are not oblivious to the fact that mere information received by a police officer without any details as regards the identity of the accused or the nature of injuries caused to the victim, cost to the victim, name of the culprits may not be treated as a FIR, but had the same been produced, nature of information received by the officer would have been clear. So in our case, there is nothing more, only to get police. So this is on that aspect. And I have only 2 more decisions to refer as far as appeal is concerned. Now, thereafter, Lordship, I wanted to place the judgment on 145 contradiction. As I had placed in one of the links, that 145 was not properly followed. That is VK Mishra, another main. VK Mishra and others versus State of Uttarakhand. This is reported in 2015 9 SCC. This is another mail. Etu mailo pa gusi jua. No. Etu mailo pa gusi jua. Arota mail. Ase VK Mishra only one judgment. Upor, yes. Upor. Up, no, after that, down below. Yes, that is VK Mishra, 2015 9 SCC 588. Paragraph 18. Lordship. This is on contradiction. Lordship will go to paragraph 18. Under section 145 of the Evidence Act, when it is intended to contradict the witness by his previous statement reduced into writing, the attention of such witness must be called to those parts of it which are to be used for the purpose of contradicting him before the writing can be used. While recording deposition of a witness, it becomes the duty of the court to ensure that part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness. Lordship, I've skipped. It becomes the duty of the trial court to ensure that part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. The attention of witness is drawn to that part, and this must reflect in his cross-examination by reproducing it. Now the thing starts. If the witness admits the part intended to contradict him, it stands proved and there is no need for further proof of contradiction. It will be read while appreciating the evidence. It will have to be placed before the witness first. If he agrees, then matter ends there. It need not be put to the police officer again. But if he denies having made that part of the statement, his attention must be drawn to that statement and must be mentioned in the deposition. By this process, the contradiction is merely brought on record, but it is yet to be proved. Therefore, when investigating officer is examined in the court, his attention should be drawn to the passage marked for the purpose of contradiction. It will then be proved in the deposition of the investigating officer, who again by referring to the police statement will depose about the witness having made that statement. The process again involves referring to the police statement and culling out that part with which the maker of the statement was intended to be contradicted. If the witness was not confronted with that part of the statement with which the defense wanted to contradict him, then the court cannot suo motu make use of the statement to police not proved in accordance with 145. This is what I wanted to place, because in one of the links I have said, without placing it before the witness, they have allegedly proved the contradiction by placing it before the police officer. That he cannot do. He has to first place it before the witness, When he'll say, no, I have not stated, it is not a fact that I have not stated, then it will be put to the police officer, not directly. Suo moto, as it is being reflected here, suo moto, it cannot be used. So for that aspect, I'm placing the judgment on contradiction. Procedural. আৰু এটা মেইল on omission বুলি লিখিছো on omission বুলি লিখিছো so yes না আগলে yes on omission yes they will get the judgment তাতে ক'ত আছে judgment আগত this is my number I have sent it later নাই থাকিবতো লাগে on omission only so Shashidhar তাতে মাৰাচোন একদম প্ৰথমতে পাব the very first question আকৌ মাৰাচোন no before that before code 7 GSC তাতে মাৰি দিয়াচোন no after Shamima Jahan মাৰি দিয়াচোন মোৰ ইয়াত দেখাইছে দি থাকে হা আকৌ পঠাই দি আছো মই পঠাই দি আছো পঠাই দিছো আকৌ
no?
আপুনি মাৰ্কছটো কৰি দিব last scene not the victim last scene with no my last scene no last scene nahe মোৰ মতে nahe last scene with the victim দেখিব লাগিব পালে লগত দেখিলে না এইটো বেলেগ কথা last scene তো হলেহে no possible আমাৰ দিয়া টাইম শর্ট আছে নাই আপনি কৈ চাওক যদি এইবোৰতো সেইকাৰণে চেইনত আহিছে তাৰমানে লাষ্ট চেইনতো গোটেই চেইন লিখিয়ে দিলো কাপোৰ লৈছে আছে সেইটো আছে লিখিছো মই সব মই চেইনত চেইনতো মই দিছো এইখিনি লিখিও দিছো after you finish
you want to know what is the root of that law laid down by the Supreme Court? You want to know that?
no Lordship, yes
You have CRPC with you.
Lordship, yes I have it here yes Lordship can say yes section
172
Lordship
clause 2.
yes 172
2.
yes once absconding to avoid service of summons
No, 172 CRPC.
for CRPC I thought I was 172 Lordship, yes 72 yes diary of proceeding in the investigation
Come to 2.
To any criminal court may send for the police diaries of a case under criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case but to aid it in such inquiry or trial.
Correct.
Yes.
So therefore, police diary is not before the court.
Huh.
You'll have to assume that the police diary, even in court, is not in court. Even if it is available on record, it is not in court.
Not in court.
So therefore, a magistrate is not empowered to look into the case diary as an evidence. Therefore, the requirement in this V.K. Mishra's case is that a lawyer must introduce the evidence before the police under 161, accost it to the witness, and then say that you have this is what you have stated.
Yes,
So it will be a positive evidence.
Positive evidence.
But normally, normally in practice, more than 90% of the lawyers will always put a negative remark to the witness. But this, according to this V.K. Mishra, also in my concept, to bring a contradiction, it must be a positive evidence,
Positive evidence.
not a
yes.
negative evidence
Not
that you
negative.
did not say before the police, or you said before the police. You did not say. That is
This is
that
what is
that is not
normally
said.
used.
So negative evidence should not be led.
Should not be read.
Genesis is 172 too.
Yes, we are obliged to know this. Yes, of course. This is on that basis.
This is what happens when CPC reads CRPC.
Yes. This is V.K. Mishra has said it. Yes. Then the next judgment, I would like to place it on omission. Why I'm placing this omission is, I've checked the case diary, of course, we
And
cannot check.
I'll show you something more.
Lordship,
You must know it.
Lordship.
this part has the same statement
Hmm?
in about 6 or 7 places.
Huh.
But I'll show you this 29.
I have some sense. I can see it from there.
No, you won't have that.
Oh, acha, acha.
There is a criminal code rules and orders.
Acha, it's a manual. Oh, no, no.
This is something
Ah,
which is
yes.
there, but nobody reads.
No, no, we have the book, but we
No,
haven't
I
recorded
said,
those.
I did not say you don't have a book. I said this is a book everybody has, but nobody reads it.
Very rarely. Yes.
Okay, criminal.
Criminal rules. Yes.
29.
29.
Documents not admitted in
Documents-
evidence shall be returned.
Which are not admitted as evidence should not be made part of the record, but should at once be returned to the party by whom that have been produced. Yes. It cannot be read in evidence, should be returned back.
So in the file breakup, you know, in the criminal courts, file A, B, C, civil it is A, B, A, C1, C2, and D. So if it doesn't fit into any of the files, it should be returned. And that is why CD is not, that's why I said, if it is not on record, it is not in court.
Not in court.
Sorry, maybe in record, but it's not available to the court.
Not in court. It's not in court. This is what 172.2.
Read with this, here in
read
this
with
book, you will find many places it is to be returned.
But again, it's written, but to aid in such inquiry or trial, that can be used only for aiding.
So this is something if a trial court lawyer does not know, he'll make that mistake.
This is so many things to know, yes.
Hmm?
And learning is endless process.
Learning processes.
Nobody
Never
can say
ending.
that I have learned something. It is an endless process. Every day we are learning.
No. You see, that is not the intention why I'm saying so. I have another intention of saying so. You see, process of learning, I'm not commenting on that. But when a lawyer does a trial court practice, this is a procedural law which he must know. He may not perfect himself, but he must, the trial court lawyer must know the essence of the rules of procedure.
This is without any doubt.
It's only for that I'm saying so. I'm not commenting on any other matter. Learning process, you are right. It's a continuous process.
Most particularly during our initial time of practice, we underwent 1 year compulsory practice. Nowadays, this is
No, Mr. Uddin, you please try to understand that two things. Number one, when you say I am practicing means it's not a perfection. It is a practice. Practice makes a man perfect. So practicing. But in your case, what happens? If that contradictions are not brought on record, the man is put to what do you call? He is sentenced to death.
it is put on
Yeah.
record in a
No, not that.
negative manner.
No, not that. You don't take it personally. But what I'm saying is that if a lawyer who handles a trial says that I'm in a learning process, as a result, what happens? The man is suffering a death sentence. So that's what I'm saying. I'm not saying that one should not. I'm not even suggesting that it's not a learning process. But what I'm saying is that an elementary knowledge has to be there
Yes,
of the procedure part. When somebody is taking up a trial, especially which leads to a life or death sentence, you can't take it casually. That's the point I'm trying to make.
Really important. Here, the main flaw that I see is non-examination of that Abul Hussain. His name finds place in the case diary, in the charge sheet, but no, I have not found out in the order sheet of the court why all of them were summoned, why Abul Hussain was left out, and the matter proceeded. That, of course, I'll
No,
place
the
the
answer is
judgment.
simple. The answer is simple. You see his serial number 13. He's brought in by the police as a witness to the seizure. And therefore, everybody missed that he is the first person to lodge, to inform the police on whose statement GD entry was lodged. So everybody forgot.
He didn't say it in the 161 also, I have informed. I think.
No,
subject to
161 is used, you see, it's a statement which is essentially a leading
correction.
questions are asked. So
Yes,
therefore, if the police does not ask, he will not say.
He'll not say.
It's not a voluntary statement normally.
Yes, whatever they ask.
161.
That is why some of them say, police have not asked me, so I have not said.
Huh.
This is what we get in some evidences.
So voluntary statements are not taken. That itself is a violation of 161. It should be the version of the no witness.
Witness,
Voluntary,
yes.
it's not there. That's why it's excluded.
But the next judgment I wanted to place on omission, because why I'm placing this is there are so many contradictions that were brought by the police officer. But what I find by seeing the records, that they have not stated at all about those aspects. The witnesses have not stated, have not touched that subject. Not seeing the private parts opened, not seeing anything like those contradictions which have come, like teeth marks, teeth bite marks. Like mother was arranging clothes, then the clothes were down towards her leg, and also one of the witnesses saying that he had come to our place, had water, and then left. So lot of contradictions are there. Dada.
Yes.
So contradictions in terms of accused PW now number 9 had not stated that he used to roam.
Both sides are represented on the prayer made by Mr. AHMR Chaudhary, counsel for the petitioner. Matter stands adjourned today. It goes after vacation. Just after ensuing vacation.
In respect of item 39, it's a partner matter. There was some confusion in the morning regarding the taking up of the matter. So we could not brief Mr. Mishra. So if the lordship takes it up on a different day, it's a partner matter. So you can take it up before the vacation, 17th. Because there's some confusion in the morning.
No,
Yesterday
right,
it's
right.
at night.
We'll take it up next week then, because I can't adjourn for long.
Yes, of course. 17th would be, because 17th is too near the holidays, perhaps.
No, not that long. At 10th at best.
10th? Yes, 10th. 10th, yes, Mr. Mishra.
10th of October.
10 or 12. 10th of October. If something happens, I'll mention it again then. 10th of October.
It's on 10th. 10/10/2023 as prayed for by Mr. S. John Leonard, counsel for the petitioner.
10th.
Both sides are present.
10th.
May it please the lordship.
My lord, item number 1717. This matter relates to pension although, but the matter is also in Supreme Court regarding sanction and all. The government was directed to file an affidavit, not file. So with the consent, my lord, this matter needs to be heard, but some documents need to be filed by them as well. May I take this matter be taken up after the vacation, possibly before the Kali? By that time, the pleadings will be complete. Else, difficulty would be there. 6 to
Okay,
10th
who
of
is for
November, if it is
agriculture? Who is for agriculture department?
I have had a word. I had a word.
Okay.
I had a word.
Okay, both
In
sides
fact,
are
it's a joint
represented
prayer.
on the prayer made by Mr. Asbani, counsel for the petitioner, list after ensuing vacation.
Would my lord be pleased to specify a date, my lord? Would my
You
lord?
make a mention, because after this, after vacations, all matters are being adjourned after vacation. We don't have, it's very difficult. You make a mention.
Right.
On reopening, you make a mention, we'll give a date.
Yeah, please.
Yes.
I am paying for listing of one repetition. Matter relates to holding of principal, charge of principal.
Okay, give it to the court master.
And similar pair is IA is for petition of Anand.
That will be good.
Yeah, please, Your Lordship. In item number 23, Your Lordship, yesterday I have filed an affidavit in reply to the affidavit. There may be called for Your Lordship. Oblige, Your Lordship.
May please, Your Lordship. My lord, I beg to mention item number 40 hearing, item number for today hearing. My humble prayer, my lord, this may kindly be listed after vacation. I have taken the consent from the petitioner.
Petitioner, madam. 2015 the petitioner has been removed from service, madam. I just paid it for a fixed date, madam. Hearing date on 7.
40. The
40.
2015 matter.
Fixed date after the Puja vacation, madam, 7th of November, madam. As per your lordship,
Give date after vacation. Both sides are represented or the pair made by the made by Mr. N. A. Singh, counsel for the respondents. Matter stands adjourned today. List on. Yes.
Yeah, please, Your Lordship. I beg to mention item number 42.
40.
42. Lordship, in this matter, we want to file a reply affidavit against the affidavit filed by the respondent number 6. On last 21/9, they had filed the affidavit.
On.
21/9/23, they had filed the affidavit in opposition.
You want time for reply?
2 weeks time may be granted.
Okay. List. Both sides are represented on the prayer made by learned counsel for the petitioner. List after the ensuing vacation so as to enable him to file affidavit and reply in the matter.
Supplementary list item 45 for motion.
Yes.
Also, the petitioner also is praying for regularization of a particular period. He has joined in service as LD assistant in the office of the Director of Employment and Craftsmen in 1988. And
It also equal.
and he has retired as an assistant employment officer on 31/3/2022. For non-regularizing of that particular period, lordship, petitioner is also getting a mega pension, lordship. And lordship, there is not a single service break. When he was released from service, lordship, this honorable court protected me by passing a status quo order. The lordship may kindly see page 30. 30. I have challenged the release order in 89. And lordship, this honorable court protected me by passing a status quo order. Lordship may kindly see page 30. 30.
Page?
Page 30. 30.
30. Oh, shows the implement 27/5/2019 order first.
Yes. Page 50, lordship.
50. You're challenging the order of 2019 now.
I'm praying for regularization of that particular period because at no point of time there was any service break. Lordship, I continued in service for page 30. 30. Because of the interim order, also I continued. I was issued in page 30, also issued notice to focus as to why these two impugning orders should not be suspended till disposal of this petition, and notice is returnable within 2 weeks. The status quo as on today shall be maintained. Because of the status quo order, lordship, I continue. But when lordship they have used the word lordship reappointment, they should have used the word reinstate. At no point of time there was any service break. I continued from 1988 till my retirement on 31/3/2022.
But during the 89 to 93, where were you working?
In the same office also, in the employment, in the Director of Employment and Customer Training also.
From where do we find this?
That is, it has been disputed by them because in the reinstatement order they have stated that I have been reappointed.
Where is the judgment of the this court 2090 that respect page 31?
Page 31. Page 31.
No, you see, not being able to follow you. You see, pursuant to the High Court order, you were appointed in the year on 1/12/93. Now, all this time, the government is always saying that you are not working in the department for that period. And therefore, the High Court issued a direction for the state to consider. There they considered and rejected your application in 2019. Now you have filed this petition to have this order reviewed in 2023 after 4 years.
I was very much working in the same office because of the status quo. That petition was pending.
No, you see,
that petition was pending and it was finally disposed of. They said that they will consider my case. That is how also this order was passed. After also I have filed another petition that has also been disposed of, giving me pay protection. What's in my kindly see case 42. Case 42 may kindly see.
Will merely issue a notice. Mr. S.K. Das, counsel for the petitioner, and Ms.
On behalf of SP Das.
You have to shout. Speak loudly.
Behalf of Mr. SP Das, respondent number 4.
Your name?
Sibora.
Tivar and counsel appearing on behalf of Mr. S.K. Das. Counsel for respondent number 4 and Mr. R. Dhar, additional senior government advocate appearing for respondent number 1 and 2. Finance and Mr. P. Nayak, standing counsel for the finance department, respondent number 3. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the Runner State and Department Council in course of the day. Next list on so and so.
Ultimately, given observation, the pendency shall not be a bar to consider my case also. Pendency shall not be a bar to consider my case also during the pendency also, if they can consider also.
Pendency of the representation shall not be a bar for the respondent authorities to consider the representation of the petitioner. Okay.
Okay.
Item 1.
May I please, Your Lordship? So, Mr. Inken, senior counsel leads me in the case. He is on legs in court 30. So, may kindly be taken after some time, Lordship.
After some time. How much time?
He is on legs in court 30, Lordship.
No, I understand, but you must tell Mr. Goswami how much.
May I suggest something? There is a preliminary objection which we have taken in our application for vacating the stay order. It relates to a transfer order. Petitioner number 1 is posted, it's Bank of Baroda, it's posted in Guwahati. He is transferred to Burdwan. And petitioner number 2 is posted at Agartala. And he is also posted at Burdwan, West Bengal. It's one zone. Calcutta zone comprises of all the northeastern states plus Sikkim. So, as far as petitioner number 2 is concerned, his posting is at Agartala. The orders of transfers are passed from Calcutta office.
So, territorial jurisdiction.
And he has been transferred to Calcutta
Okay.
zone. So I don't know how he can file this.
No, but normally transfer petitions, they have to be independently taken up. The two people can't join. Cause of action can't be same.
Cause of action is never same, but in this case, I think they should. We have taken this in our application.
Let it be after some time. You just tell us the time. We don't want senior counsel to sign.
I was thinking, maybe you may consider, you may file a, because appropriate court will be the Agartala court, High Court. So your lordship may give them a little time to file that. Till then, the stakeholder may also.
No, it leads to another difficulty, Mr. Goswami. You see, writ petition, for part of cause of action, one of the, I can't technically issue an order to one party to go out.
Because otherwise, I don't see how he can add himself as a party petition.
And if I this is another thing, if I pass an order for deleting the name of the respondent 2, then again there will be consequential amendment in the writ petition. Has to be, because pleadings in respect of respondent 2 cannot stand.
So, because that will go. His case in the petition is that petitioner number joins because it is of the same time. And that doesn't confer jurisdiction on a court if it doesn't have.
Okay. After some time.
He's still on legs.
Usually he could have done it at Agartala because he is posted there, he is getting ordered.
So when do you propose to come again?
No, I can, whatever time, if they want time, let them take the time and consider. They should do that because
He's doing it today.
today.
He's in different another court. He's on legs on another court.
Lordship may also fix after any other date on that day. That point.
No. Very difficult to get it listed now. Before vacations, everybody wants the matters to be listed. When matters are listed, they have request for adjournment. They are unable to cope up at this point of time.
Lordship,
After some time, then. After some time, inform Mr. Bora so that Mr. Goswami can come.
yes, Lordship.
Item 2.
Hey, please, your lordship.
Yes. Whom do you want to implead?
Yes, my lord, he's the mother of the deceased.
Mother of the deceased,
Yes.
respondent number 5. Okay. You are on the application. Okay. Ms. K. Devi, learn counsel for the applicant. And Mr. M. Hussain, counsel for the opposite party number 1.
Writ petitioner.
Your opposite party number 1 here. Opposite party number 1. Finance taxation. Who appears for finance taxation? Mr. B. Gogoi. Mr. V. Chaudhary, standing counsel for respondent numbers 2 to 5. Opposite parties number 25. Next paragraph. This interlocutory application has been filed for impleading the applicant, comma, the mother of the deceased as respondent number 5. Full stop. The the 5. Full stop. The next paragraph, the said prayer having not been objected to stands allowed. Now, write in the merit petition.
Need petition, my lord, already respondent number 5 was impleaded.
Huh?
It should be 6, my lord.
Impleaded already.
It should be
impleaded
6.
at the 5. Now, new.
Should be 6.
It should be in 6.
6. Okay, make it
Yes.
6. As
Not
number 6. In the replacement, right? Mr. M. Hussain, counsel for the petitioner. Mr. V. Chaudhary, standing counsel for the Finance Taxation Department. And Ms. K. Devi, counsel for newly implemented respondent number 6. Next paragraph. In terms of order passed today in the connected interlocutory application, comma, the registry shall implead the applicant whose particulars are available in the IS Civil 28000 of 2023 as respondent number 6. Full stop. You have the copy of writ petition?
Yes.
Okay. How much time for affidavit?
After petition, my lord.
Okay. List immediately after the ensuing petition, by which time the respondent shall file their affidavit in opposition. Mr. Hussain, make a mention after vacation for date.
My lord, but the applicant is not impleaded, my lord, till date. I have to file
Who?
opposition.
Order has been passed.
My
Pardon?
lord, that is, I submit before your lordship that I have to file objection regarding the impleadment, my lord.
Impleading is allowed. You said no objection.
No, my lord, I submitted before your lordship to file objection, my lord. I prayed for
You
time
want
file
to
objection.
file an objection.
Yes, my lord, because no need to implead the party number 6, because my lord, the applicant.
No, you file your objection, then we hear you.
Yes,
No
my
point
lord.
hearing you now.
My lord.
Ms. Kedevi for the applicant, which is the interlocutory application is for impleading the mother of the deceased as respondent number 6 in the connected writ petition. The counsel for the writ petitioner prays for some time to file objection, list after ensuing vacation, by which time objection to this interlocutory application shall be filed.
Item 3 to 11 for an
Item number 1, we have discussed it may be fixed after vacation for considering the entire application for disposal.
He is suggesting that both vacating application plus the writ petition may come together after the vacation.
No, once objection of territorial jurisdiction is taken, I can't do that.
Lordship, then,
It will be impermissible.
lordship, then,
Both all will be open, my lord. You got lordship.
No, because you see, if I fix it, if I pass an order, I'm bound by the order. Then we hear only on merit. But if it's a preliminary objection, I must decide the preliminary objection first. That is the law.
The hearing has not taken place. We will take the
No,
preliminary.
but we're not saying that in the order. We just adjourn it.
Adjourn it for 9th. You know,
9th
9th.
of
He wants it on 9th.
9th
That is a
of
Tuesday, either Tuesday or.
9th of November.
Yes.
Okay. Mr. P.K. Goswami, Senior Counsel, assisted by Mr. V.P. Bora, Counsel for the applicant, and Mr. D. Decca, Counsel for the opposite party number 1, obligated petitioner.
and 2.
Full stop. On the
There are 2 written.
for the respondent 1 and 2, writ petitions.
Vacating also, my lord. Both.
Huh. On the prayer made by the counsel for the opposite parties number 1 and 2, this interlocutory application and the connected writ petition are adjourned. List on 9/11/2023.
Earlier interim order can be.
Okay. Interim order passed at least stands extended till the next date of listing. Okay, you have filed your objection here.
Yes, lordship.
Okay.
Readings are complete, I think.
Okay.
Lordship can finish it off.
We are fixed on 9/11, as suggested.
Highly obliged.
Item 3 to 11 for admission.
In this matter, Lordship, what has happened is that there are two schemes, Lordship, NEIP 1997 and 2007. So there were some confusion about who will approve these claims. So regarding that, Lordship, there was some clarification to start from the central government, DIPP, Department of Industries. So that clarification hasn't come. So recently they had a VC.
But this scheme was already closed.
Actually, scheme was already closed.
So after close, the central government is not notified. Who will be the authority to approve it?
Correct. Lordship. So that is the issue happening. So
But this is never going to come. The central government is not relaxing it.
So yesterday, now thing is that yesterday only I have got this letter. They have sent a letter to the DIPP, Lordship. So as per this, like they are seeking for a clarification whether this SLC can approve it or not. Because earlier the provision was different because it was directly paid by the insurance company.
The scheme was recently closed, Your Honor. Matter is pending since
So
2006.
almost 101 claims are there also. Yes, similar claims.
No, but you see, Mr. Kalita, this is going to take us, this letter is going to take us nowhere. Now, this earlier when the policy was in place, it was in vogue. Then who was the authority to approve it?
At that time, also whatever once the premium is paid, then it will go directly to the national insurance company. They have a corpus fund. So out of the corpus fund, they used to pay it. So now this under the 2006, under the 2000.
Slightly misleading, Lordship. The claim is we have to file the
The
claim to the
processing
industry
is-
department.
To the?
Industry department. The industry department has to process it and place it before this SLC.
No.
Once the SLC approves it, then it goes to the central government for release of the fund.
No, that is not correct. That is not correct.
That is as per the
NEIP,
scheme.
NEIP 1997, it was different because that was a, and they'll have to, obviously their processing
No,
has.
that is the industry scheme. This is an insurance subsidy scheme.
Correct. So what has happened, they used to, central government used to maintain a fund with the national insurance company and they used to pay it. Now under this 2007 scheme, the scheme has been changed because it will go to the SLC, then net fee will pay it. So now SLC is finding difficulty because all these claims are under that 1997 scheme. So whether SLC can approve it or not. So that was a difficulty they are having.
No,
So-
no, you see, whatever you do, you release it from your end. It will be the competent authority who will say that you are not competent to approve it. You see, it's a 2017 matter.
Correct.
Now we are in 2023.
Yeah, exactly.
If the government doesn't know who is doing it, then why you are accepting the application?
No, Lordship, what can be done in my humble submission, Lordship, central government study council was there in the last occasion. So if he can take some instruction on this, because this letter has gone to a central government and they can update your Lordship.
No,
on this.
you see, when the scheme is closed, why should the court ask them to take a decision? It will be between the two departments.
Only the clarification, Lordship, part.
No, it is between the two departments. Why would the court ask X or Y to give a
No, they are
explanation?
also party into this. So like, Lordship, if they can come up with, because we have that last occasion, Mr. Chaudhary was there. He was asking me that if the letter can be given, then he can maybe seek some kind
You
of.
ask him, you request him, we can come here. Because technically, you see, if an application is before the authority X, He takes a call.
Because
He either this officer will either approve or disapprove it.
no, because lots of what has happened that 1997 scheme came to an end in 2007. When 2007 scheme came, and under 1997 scheme, the SLC thing was not there. In 2007, the SLC has come, and like disbursing authority has been
You see,
notified.
that's why I asked the question. When the scheme was discontinued, who was the last authority who was approving it? If it was the SLC, let the SLC take a decision.
Now SLC, what SLC's version is that, Lord, see, what I'm talking about SLC's version. SLC is saying that they are not.
You see, nobody wants to work.
Yeah,
As simple as that. You see, if the authority says that we have received it and you are processing, we find it admissible or not admissible. And it is for the paying authority who will say that you don't have that authority. But why will you keep it pending for 6 numbers of years?
That is correct, also. I understand that, also. But now the position with the department is that like department is not clear, like whether they have the power to approve it, because those claims are from 1997. So only that clarification is there are 101 applications are there, I'm told. So 101 applications are lying like this because of this, and they had a VC as per that like last August only also. After the VC, like this clarification was sought for. It is mentioned.
No,
there.
this is not an application. At your end, you can you have the standing council. You can instruct them to do that work. Why would we keep it pending? Otherwise, we adjudicate it. After 6 years, if the interdepartmental communications don't come, should the court wait for that amount of time? We hear it. You start your argument.
Well, also, I mean, otherwise these applications have been forwarded and processed, and an amount was also this thing mentioned. But
No, then we take a decision.
the only thing is that, Lordship, only because now SLC is saying that because
No,
we
you
are
see,
not
you have two
involved.
options. Number one, you can find Mr. R.K.D. Chaudhary, bring him. This is first option. The second option is that if the authorities, the SLC, they can pass orders and dispose it off. And number three, you permit the court to proceed with the matter. We hear it and finish it off.
Then Lordship may kindly, if Lordship allows me, like give me at least allow me 1 week time, then I'll file an affidavit bringing this on record. This and like some other bunch of papers they have given me.
No, you don't
yesterday.
need an affidavit for that. If I'm hearing the matter, we take it on board.
Yes, sir.
You start your argument.
I mean, Lordship, I mean, otherwise, I mean, this is processed and this amount was also forwarded. Only thing is that the power. So I don't have any other things.
Power
to
will
assure us.
decide. We'll decide that. Who has the power? We'll decide that.
Because
No,
1997.
but why should this writ petition be kept pending in the court because of your indecisiveness? Then you permit us to hear it and dispose it off.
Let Rakesh Chaudhary come, like, if he can help us, because
You
Lordship, that
find
will be
him.
a help.
You find him, we'll take it up.
Lordship, I'll just try.
Huh. Because the answer is simple. Since I am a creature of CPC, if I get it, if it is without jurisdiction, I return it. We have the consent or return of the plaint. So therefore, when a matter comes to supposing I am the officer, if I receive a document which is not to be processed by me, I return it. But where is the power to the officer to ask for a clarification whether I have power or not? Now, this is who will decide.
So what has happened is that in the 1997 scheme, NEIP scheme, the SLC.
I'll tell you something from the scriptures. They may be right, they may not be right. You may believe it in it, you may not believe it in it. But you see, what happens was when Lord Ram was in the process of finding out Goddess Sita, then he took the assistance of Lord Hanuman.
Correct.
And Hanuman had the power to go to Lanka, but he did not, but he was not aware of that power. So people had to do that Hanuman Stuti, you know about it.
Yes, yes.
The Stuti was done and then he remembered his power and jumped,
Correct.
went there. So we have historically known what you call examples of people reminded of their power to do it. But where do you find historically that somebody will think, oh, where I have power, whether I have power or not, I'll ask X, I'll ask Y, do I have power? It's not envisaged in a government. If the government If the government starts thinking like that,
The only thing is that Lordship, that is the scheme is silent about this.
no, no,
Because the
it's
scheme
okay.
says about
No,
that
but
you will
then
allow, you will allow.
This officer is having some qualification. He is a qualified person. He's not what you call
No, it's a high power body,
grade
Lordship.
3, grade 4
It's a high power
authority who is handling it.
It's a high power body.
So if a government officer has is a qualified person, let him take a decision. Why should he ask? If he asks that whether I have power or not, he is incompetent.
When the scheme.
You say that you give us time. We say that we record his incompetence and then proceed.
The problem was Lordship, like that scheme was silent.
No, you get Mr. Chaudhary, because otherwise
Lordship,
it doesn't take us anywhere.
For time being,
Half a time being. Yes, 12.
Item 12 to 14.
You have the service rules.
Service rules in my position.
You have a good copy of service rules.
Right now, I don't have.
But that is the last order.
Yes.
Yeah, thank you.
But you see, just tell me how can this be done? There was a delay in promoting you, correct? There was a 6-year delay. Now there is a date of your promotion. Let us assume that there is a date of promotion. Let us assume 1/1/2000 you have been promoted. Now you are saying that you consider it from the back date. Is it permissible in service law to have the what you call order passed today antedated for promotion? Can that be done?
Election provision of is there for relaxation of the time. Earlier it was done in the forensic science level.
Oh, earlier it is done. It is an illegal act. It is an illegal act. How can a promotion be antedated in service parlance? I could have understood if there's a writ petition and the writ petition order says that it will take effect from a particular date. That I understand, but administrative orders or the court orders, prospective court orders, antedating your date of promotion. It's not permissible. Huh?
40 day.
No, not for the day. It goes after vacation. But that is the only point here. Can it be antedated? Can promotion be antedated?
No, because affidavit has responded.
And these are scientific officer. I think APSC is required. APSC approval is required. So APSC rule doesn't have that antedating.
My lord, Lordship, in case they want time, my lord.
No, I'm just trying to understand. This is when it's a question of antedating.
No, that
It was.
that cannot.
13 Lordship. He's holding the charge of that post.
And if they
No, if you are holding a charge, it doesn't give you entitlement to be promoted to that post. You are merely holding a charge. Your substantive appointment is of the lower cadre.
What our contention in the references are that Lordship, there were vacancies at that point of time. In spite of there being vacancies and there being a prescribed quota for that exercise to be done, they have not notified.
But merely because of that, can promotions be antedated? That is the question I'm asking.
our contention was that no exercise was being carried out at that point of time.
You did not come at that point of time. You are coming now in 2018. This yours were filed in 2017, and you are claiming that the existing vacancy at that point of time was of the year something 99 or 2000. I forgot the year. I won't remember it. So you see, at this point, when we are passing an order, at that point of time, the claim would be, if it is 2000, now we are 23 years. And then your petition will fail for second reason. Any person who are intermittently affected by your antedating of your promotion, they are required to be made parties. Whether you, once that prayer is made, others have not.
There were no promotions being affected.
No, I'm not saying that. You see, what I'm trying to ask from you is that your claim, let us assume it is for year 2000. You want it to be antedated to 2000. Your promotion was given, let us say 2005. Now you want it to be antedated to 2000. Now from 2000 to 2005, anybody who have been similarly situated, they are required to be made parties, because you can't be picked and picked up and then given a promotion. All others similarly situated have to be considered. Are they parties here? Are they parties here?
We were the senior most otherwise Lordship, in those departments. We were the senior most in those departments. Lordship.
You are the senior most. If your promotion is antedated, nobody will be affected. In the line, nobody will be affected. Where is that statement in your petition?
In item 15, considering his seniority, he was given all the charge of that because of his seniority.
No. You see, what is the rule of the DPC? How many candidates have to be considered to give you promotion? A DPC will have a set of regulation that if there is one post, it will be 3 people who have been who will be called. There must be something like that in the DPC, or DPC will choose only one person who is senior, others will not be considered. What is the DPC principle followed here? Let me adjourn it. We'll take it up after vacation. Also, is a duly represented on the prayer made by counsel for the petitioner matter stands adjourned today. List of
APC,
tension.
I'm for respondent, except APC.
I said all sides. I'm not writing the name. List of tension, puja vacation. You make a mention if it is not listed. Yes.
Nothing.
Yes.
Sorry, Lordship, I was in.
It's okay. You have to move your office and give them power.
Lordship, he has informed me, Lordship, that there has been some communication, Lordship. If he can give me a copy of that, Lordship, I'll take it up with the authority.
By how much time?
Lordship, give me 2 weeks' time, Lordship.
No, because you see here, the question is that the state thinks that it doesn't have power.
Yes.
So they want to know which department would have the power.
It's
Now the
otherwise a
scheme
very
is
simple thing.
scheme is closed. I don't think under the circumstances the government of India will allow them to reopen and
That is my
revisit.
view also, Lordship.
Correct. Now, the question is that if there's any delay in the adjudication, what you call this adjudication is delayed only for that reason. Now, either you give them power or they take their, assume their own power and do it, or otherwise we hear the writ petition and dispose it off.
Yes.
This is a 2017 matter. We don't want to keep it pending. So we, on papers, we say 2 weeks, but it will come after vacation.
Yes, in that case, Lordship will say 10 days, Lordship, because I have to make the move.
Okay. Dr. A to the counsel for the petitioners, Mr. Architect DSGI, and Mr. A. Kalita, and standing counsel for the Industries Department. Next paragraph. The Donut standing counsel for the Industries Department has submitted that communication dated 10/8/2023 has been issued by the Commissioner of Industries and Commerce, Assam, to the Director, to the Director to the Government of India, Ministry of Commerce and Industry, seeking certain clarification. First of all, Mr. Architect Chaudhary, DSGI, seeks for a copy of the said communication so as to enable him to obtain instructions, for which he prays for 2 weeks' time. Next paragraph. Considering that the communication was issued on 10/8/2023, the court is inclined to grant 10 days time to the learned DSGA to obtain instructions. Full stop. Next paragraph. The pendency of this repetition shall not be a bar for the competent from the authorities who were earlier exercising power in the Industries and Commerce Department to consider the claims of the present petitioners. Full stop. Next paragraph. It is made clear that if the clarifications is sought for is not forthcoming, then the court would hear the matter on merit as the petition relates to the year 2017, and no further adjournment will be granted to any of the parties. Communication may be exchanged in the meanwhile between the parties. List in the week commencing 6/11/2023. The learned DSGI is as well as the learned standing counsel for Industry Department, Assam, are permitted to send the downloaded copy of this order to the authorities to enable them to obtain instructions.
Let it be on 6th of. Let it be fixed on 6th instead of week commencing.
No, 6th, I don't know the. I have to give the registry some leeway. Otherwise, what is happening? Every matter after vacation, they're in a tight spot.
Lordship, because.
Hearing because 8/11.
8/11 then.
No, Lordship, 8/9, Lordship, I will be in Aizawl.
Okay.
16/11.
That is fine with me.
15/11.
That is fine.
15.
We'll hear the matter on merit then, if nothing is forthcoming. Your communication.
क्या 1014
Because Mr. Kalita, I have also clarified the authority was earlier doing it, may do it. I have also stated in my order, the earlier authority who are doing it may do it. So I've given both of you your own cup of tea, and then it is for you to either consume it or then we adjudicate.
I hope something will come up. Chaudhary is pursuing it. No, I'm not very hopeful, Lordship.
You're not very hopeful. Subsidy scheme which is closed, the central government will not be able to do it. There are procedures.
I am instructed that the last BC they have happened in the departments. They were positive about this 101 applications. So I'm not
No,
sure.
positive is okay, but you see, these policies just come, don't, this, what do you call these policies, will not come without a cabinet decision.
In any case, Lordship, when a policy is closed, Lordship, normally they give up 2 or 3 months leeway in between if there are some pending applications or to be considered. So that is also good.
No, I don't know, I have my own reservations.
Let's hope, Lordship.
There are events which are forthcoming. Those are to be considered.
Yes, Lordship.
Item 15.
We are working in the director's lordship and they are seeking the pay at par with the incumbents.
Pardon me?
These incumbents are working in the directorate lordship and they are seeking parity of their pay to that of those working in the ministerial service lordship. Finance have filed an affidavit. They have also filed a reply to that lordship. Otherwise, the other respondents needs to reply also, lordship, because that would have a bearing lordship.
General administration of the general
To work in a department to department varies, merely because there is a same nomenclature. Will you be allowed pay parity? And whether the court can adjudicate and hold that this work of Department A is same as the ministerial staff of same work of Department B.
What lordship will have to determine.
Which is the department?
They working director in different departments.
Which one?
They are in different departments. They are working in various directorate offices, lordship, and they have joined hands together. In all the directorate offices, lordship, they are being paid lower than than those in the ministerial staff service, lordship. Petitioner 1 is at paragraph 2. I have mentioned lordship from where they have where they belong, lordship. That is the problem, not in only one department, lordship. In all the departments, lordship, that is being faced.
But fixation of pay scale is a totally a sovereign function. How can the court adjudicate and say that pay X so much of salary, pay Y so much of salary?
At least the contentions in the repetition logic have not been responded to by other respondents logic, because logic there was a process being initiated for that bringing about the parity logic. But then
No, you see, it will be the what is called. There's a pay department. What is it called? Is this pay recommendations are made by whom? What is the name of the department?
It is recommended by my lord the pay commission.
No. There's a pay research.
Yes, PRU, finance department. Finance department, there is a branch, it is known as PRU, pay research unit.
Pay research, huh? So it is for that department to take a call. Yes, other departments' opinion is not necessary.
An affidavit on behalf of finance PRU department has been filed.
Has been filed.
Yes,
What is your stand?
My lord, we have negated the claim of the petitioners on the ground that there is no specific recommendation from the pay commission. Now, the pay commission is an expert body which is constituted periodically to fix the pay structure of all the employees of the state. Now, there is no specific recommendation of the pay commission.
New pay commission has not been announced.
The last was, my lord, the seventh pay commission that, my lord, was constituted in the year 2017. And on the basis of that, my lord, the ROP rules of 2017 has been published.
So next is due when?
Next will be, my lord, after 5 years, my lord.
After 5 years is already over. So now it's time to
Yes.
have it.
Yes, that is a constitutional.
Because Mr. Sharma, we can only say that we can only permit you to file your representation when the pay commissions are constituted. The court will have no power to adjudicate unless you can show me some authority where the
will kindly turn to page 28 once.
28.
This is from the General Administration Department. The first one, all heads of department Ministerial Officers Association. Number 1, a claim equalization of pay and other allowances of ministerial officers of HOD with the ministerial officers of Secretariat. Against that, the committee said, the committee found that the demands are not within the mandate of the committee. Number 2, HRA for employees working in Guwahati should be 15% of present basic, or government should provide government quarter. That is not there. But then in the right hand column logic, the administrative department may however examine the demands. Those were they are sent to the administrative departments in respect of all fisheries, but then that part logic was subsequently not discussed again.
Wait for the elections. The government will provide houses to you. It is only a what you call poll promise has to be made by the government.
The recommendation here in by
How many government employees are there in the state?
there must be many, but
How many?
that I don't know, Lordship.
5 lakh government employees. So we need 5 lakh houses. Are you aware of the what you call the UN study on what is this place? It's now Libya. You've seen the economic study of UN on Libya. You see, if there is a standard rule formulated by the UN, the authorities who have done that research. It says when the government expenditure on staff exceeds 17%, then it will lead to government failure. Libya is a failed state. You search in your mobile, Libya failed state reasons, and you will come to know that. when there is an expenditure of the government on staff employees, more than 70% of the GDP, it leads to a state failure on all fronts.
That was at the last day's lordship, but in
No, but you see,
1998 lordship itself. This,
no, but you show us that which department you are working. We'll ask someone to go there and inspect. Which office?
the
Craftsman and training. This is the office we all know about. Will you find people there if you now go? In that office, if you go now in Rehabari, will you find anyone there?
outlaw.
When you say pay parity for same work, Pisciculture department, can we send a person here and will you find the full strength of staff there? Right now, if you send someone, you send Mr. Nayak is the no, I'm just saying in a lighter tone. He's from finance, so that he will give a correct report. So you see, pay parity, you must show that the same amount of work is being done. And there is no scale by which we can say X is working more and Y is working less.
That is to be determined by the authorities, lordship. But then the discrimination between the directorate, incumbents working in the directorate and those working in the secretariat.
No, you see, it can't be a universal rule because it will lead to circumstances which we can't control. Now, let us give us very simple example which you have all seen. I have held court till 8:30 in the evening, and not once, twice I have done it. 5 o'clock is a regular time when I move out, unless there is a meeting. So, court working hours prescribed in the rules are 4:15. Correct. So, if I am taking up bench till 5 o'clock, all my support staff are working. Office hours closing time is 4:30. If you care to stand at in the court outside the court at 7 o'clock, you will find from that time many of the honorable judges, and after that their staff starts moving out. So, what is the parameter of assessment of the work being done? And how will the court arrive at a finding that X is working more and Y is working less, and there should be a pay parity between X and Y? It is for the pay research unit to say that they are doing the similar type of work.
Not
The
so
court can't.
because there were discussions being made earlier also with regard to this issue.
No, is there any decision in the entire country where the courts have found out pay parity and then said that two departments are working, giving same amount of work and then fix the pay?
It's the same department, lordship, wherein the ministerial staff are being paid more, wherein the working in the persons working in the directorate are being paid less, lordship. That's the grievance, lordship.
But services are different. They are under two different classifications. Otherwise, the government will not keep two service rules. Why they have kept two service rules? If these persons are doing the same work.
Maybe, lordship, but then this issue was pending since long, and there are several.
No, means you see, the rules are framed by the rules are 309 rules.
Lordship.
Framed by the honorable governor. Correct.
Lordship.
Not and the governor works on the advice of the chief minister and the cabinet. Now, all these people must have some sense of responsibility to frame two sets of rules. Why these two rules? Why these two pay scales? Is there any research by anyone saying that these two establishments must be merged together? You see, I'm asking you a question for a reason. I'm not asking just for nothing. At one point of time, the government of Assam, after research was done, the establishment in the deputy commissioner's offices were merged. 2 or 3 different departments which were working under the deputy commissioners were merged, and then there was a consolidation of the establishment of the deputy commissioner. You know that you have done so many cases.
It's true.
In the amalgamated, what you call office of the deputy commissioners, then there was pay disputes within so many people, and I think you must have done a lot of cases. So you see, it's only when the various departments are merged into one, then the question of pay parity can be decided. And the courts, we have held it, that if they may also pay same pay scale. The distinction between the two service rules were not were removed. But in these cases, in 2 departments, how can I do it? You show us the power. You see, two more things. Number one, what fundamental right has been violated?
Because they are working in the same department and in the.
But it's not a fundamental right. I went to the eyes open. You resigned from that post. You find some other job.
That is one solution.
But you see, you with your eyes open, you go to the establishment.
Earlier, there was not much difference, Lordship, but now it has become.
No, whatever difference was there may be a difference, may not be a difference. It doesn't mean that at one point of time, if there was a same pay scale, the government can now not give 2 pay scales if they are 2 different establishments. Yes, Mr. Porpujari, what do you have to say?
My lord, in the application, my lord, filed on behalf of the finance PRO department, the specific stand has been taken, my lord, that their nature of duties are totally defined with the duties at par of which, my lord, they are claiming the relief of pay parity. And my lord, the repetition is founded only on the premise, my lord. If my lord may be pleased to come to page 16 of the repetition.
15.
16, 1-6. Exactly what is the prayer?
Yes.
Page 16, my lord, within the nature of mandamus, like nature, directing the respondents to bring in parity of pay with respect to the ministerial staff of the heads of the department at the directorate's office, at par with that of the ministerial staff of the secretariat. Now, my lord, the ministerial staff working in the secretariat are endowed with more responsibilities. That is the specific stand taken here. So naturally, they will be getting a higher pay. And my lord, the one another aspect of the matter is, my lord, the mode of recruitment. That also plays an important role here. How the people are recruited, then what is the eligibility criteria? Altogether, these things are defined. So there cannot be any pay parity.
What is the distinction?
My lord, the distinction with regard to the mode of appointment, how a person is appointed.
No, what is it? They come through the same process.
No, they are defined modes of appointment because, my lord, the establishment of secretariat is altogether a defined establishment. Then the heads of the department under which they are working under the office of the directorate, that is altogether defined. That is one
Okay, we'll
aspect.
continue to. I overshot my time.
Yes.
Two. You just explain that to me.
Definitely.
Mode of recruitment and mode of those things which you are saying. Just explain it to us.
Yes, my lord, in fact, we have spelled it in our affidavit, my lord. I will be
Okay, just
inviting
refer
my
it
lords
to.
the amendments made in the affidavit. That will clear the picture.
They have also finally replied to that.
Okay, we'll take consideration.
Obliged. Just knowledge.
এইটো মানে এইখন মেনচন মেমো ঘূৰি আহিছে এইটো মানে পাৰ্টি ক্লাছটো ৰাস্তাটো ক্লিয়াৰ দৌৰা-দৌৰি লাগে কেতিয়াবা আমি প্ৰতিবিলাকতো কওঁ আৰু এইবিলাকতো কওঁ এইবিলাকতো এটা সেকশন এটা লগ এই লেকচাৰে হওক বা ৰেগুলাৰে হওক আচ্ছা কোৱা জনাবাহে এই ৰাতিপুৱা মানে আকৌ আজি কৰ্কখানৰ ওলাইছিলে ইমান ভয় কৰিবলগীয়া নাই কৃষ্ণৰ নাম লৈ দাদা মই হাইকোৰ্টৰ পৰা দাসে কৈছিলো এতিয়া কালি যে আপুনি ক'লে এতিয়া উকিলজন যদি কেছটো ধৰক মঙল বুধবাৰে উঠে তেতিয়া উকিল থাকিব নাথাকিব ঠিক আছে জনাব কাৰণ কি শনিবাৰে মানে আমাৰ জাজ নাহেতো এতিয়া শনিবাৰে মই ধুনীয়াকে লাগি দিব পাৰিম, কিন্তু মই যদি লাগি দিওঁ, এতিয়া যদি কেছটো যদি অহা সপ্তাহ উঠে, তেতিয়া আকৌ আপোনাৰ উকিল নাথাকিলে কথাটো অৰ্থহীন হ'ব নহয়। হ'ব আপুনি আপুনি খালি ক'ব যে অহা সপ্তাহত উঠালে তোমালোকে পাৰিবনে নোৱাৰিব, উঠাই দিম হা। শনিবাৰে মই সময় পাম, মই তেতিয়া ঠিক আছে। না এইবিলাক এনেকে ওলাই মানে এবাৰ উঠাৰ পাছত যদি ওলাই পৰে এনে বেয়া দেখা যায় ন এইবিলাক সেকশনতে পেলাই দিব লাগে। ভয় কৰে ন, আগতে ময়ো কিবা ইমান নাজানিছিলো নহয়, এই বেলেগ ষ্টাফে এনেকৈ পেলাই দুবাৰ লিখে এই দাস আপুনি মই জানো এইবিলাক অৰ্থ নাই। নিজৰ অফিচত খাই লাগিব, আমি আমাৰ নিজৰে খাই, কিন্তু কিছুমানে অলপ বেছি কৰে ন, সেইকাৰণে মোৰ বেলেগে নেদেখে। এই ছাৰৰ ইমান শুনিব মন যোৱা নাই। এদিন MFA, FA এইবিলাক লৈ মনটো অলপ হেৰি হৈ আছিল ন, আকৌ আজি দিলে বেলেগ কৰি আৰু মানুহে আৰু কিমান আৰু এইবিলাক এনে আজি শৰ্টকাট মাৰি আছে। সেইটো মানে আপোনাৰ মোচনত আছে যে সেইকাৰণে সেইটো চবতকে আগত নকবা যে মোচনৰ এটাই আছে। ইফালে ছোৱালী কি কৰা আহিছে না হয়। এইটোৱে এইটো ধৰক 12টামান বজাত হৈছে আৰু কৃষ্ণ। এতিয়া আইটেম 15 আছে ছাৰৰ মানে এপটো আধা কৰিলে বেশি খেলিমেলি লাগি আছে না ঘোরাঘুরি তো হয়েছে এখন পেনশন মেমো আপনারটা জমা আছে তো 9 তারিখে বিচারছে এই বেঞ্চতে যাব কিন্তু মানে যদি বেঞ্চত যাব আজি চাকরিতে আহিব যাব মই এতিয়া কালি তথাপি ছাৰৰ ছবিটো হলেহে ইয়াতে আহিব কিছুমান ফাইল আহোঁতে দেৰি ফাইলে আইটেম কিমান ইয়াতে আছে ফাইলটো
বুঝি পালো ফেকন ডিসপ্লে দিদি
কি আছে আপোনাৰ এইটো কেছে কাইলৈ উঠি যাব আপুনি টেনশ্যন ল'ব নালাগে হা ফাইল এফিডেভিট লাগি যাব আপুনি আৰু খবৰ ল'ব নালাগে হা কিন্তু আমি চিন্তা কৰিম আপোনাৰ ফাইলত কাইলৈ এই যে ফাইলবিলাক তাত আছে এতিয়া আমি এটা কথা চাওঁ কাইলৈ আপোনালোকৰ কাইলৈ কাইলৈ লিষ্টত আহিব আৰু এফিডেভিট লাগি আহিব আপুনি টেনশ্যন কৰিব হা
এটা মোটা বঢ়িয়া but তই টাইম মাৰি দিবি টাইম মাৰি পেলাই তই পেনটো উলিয়াই ল'বি ন পেনটো উলিয়াই পেলাই তই টাইম কৰি দিবি মতে বনাই দে সেইটো মোবাইলত চেণ্ড হৈ যাব সেই PDF কপিটো তই যি এডিচি আছে সেই এডিচি পাৰ্চনেলি তেওঁক ফোন কৰি
শনিবাৰে
দিব পাৰোঁ তেতিয়াহ'লে একেলগে PDF কৰি দিলে একেলগে স্কেন কৰি দিলে এটা PDF ফাইল বনাই দিলে হৈ সময় এটা মানে সেই পাছৱৰ্ড এটা চলি আছে সেইটো 7 নম্বৰ আছে দুটাবোৰে আগতে তেতিয়া মই কাৰণে তেতিয়ালৈকে বুলবুলিটো বৰ্তক কৰি দিলোঁ
বাকী বেঞ্চৰ কেইটা দেৰিকে উঠালেও মই দি আছো খাৰ উলিয়ালো বেয়া লাগিল দিয়া তুমি এটা এফিডেভিট আছে সেইকাৰণে পঠাব লাগে বৰা এই এচিটো দি দিয়াচোন ভাত পানী খালে গৰম লাগিছে এতিয়া মানে ঠাণ্ডা লাগে ন
No, tomorrow, no, it goes after vacation.
Because my senior will be making submission within days. My senior will be making submission within days, so it's requested the matter to be accommodated.
It goes after vacation. Outside the dues represented on the prayer made by council to the petition. Matters is adjourned today, just after ensuing visa vacation.
Bless.
Item 16.
Yes.
But I need little accommodation. I have sent the affidavit for vetting. It will come in a day or two.
2019 matter, is still in waiting.
There is a direction on 14/9.
I can fix the matter next week also.
Will come.
It will come back. In 2 days. They promised me that in 2 days we are sending it.
Okay, then Wednesday. Both sides are duly represented on the prayer made by Mr. Ardhar, learned additional senior government advocate. Matters is adjourned as he undertakes to file affidavit in opposition within 2 days. List on Wednesday, 11, 11, 10, 10, 2023. Okay. In fact, Mr. Dhar, these matters don't even need an affidavit.
Exactly, madam. But
Then
what I really wanted is this affidavit will help the petitioner. That is what I told him. That this affidavit come, this will help you.
no, because see, the Upen Das is there. Why we need an affidavit? On the
My lord can take it. I don't have it. Based on my written instruction, also my lord can take it.
because your instructions can't be better than Upen Das.
Because my lord, my instruction is contrary to the Upenda. That's why my lord will take it all on it only.
Honestly, these things are pending for since so many years.
This is the way Upenda is the only.
Item 18 to 20.
This is also same thing, Upen Das, minimum pay scale.
I am waiting for item number 19 and 20. I asked Sritya for
If it is same Upen Das, then we can dispose it of. The same direction. Mr. Papujari, you are not disputing because now Upen Das is also a policy decision of the state.
Yes, madam.
No, we are the copies of the establishments. My lord. We are working as a copyist.
No, whatever is there, that's not important.
And my lord, we are praying for minimum scale of pay.
In Upendas manner, paragraph 22, that the term was that manner there will be no more regularization, but taking a cue manner from the Singh manner, the employees who have been working continuously for the last preceding 10 years would be given the minimum of pay scale. To that extent, manner, the finance department has issued relevant notification.
This is what I'm saying. It's a now policy decision.
Yes, policy decision. Now here, manner, in this particular matter, manner, we have not received any proposal because that was a one-time exercise. After pronouncement of Upen Das, the finance department invited all the data from all the administrative departments. Thereby, all the administrative department had given their the list of employees. with a checklist, my lord. Here in this case, with respect to the petitioner, that proposal has not yet come from the Home and Political Department, and that we have specifically pleaded in the affidavit.
Shows that.
Lordship may kindly come to the affidavit filed by Finance Department that starts from page 55, my lord. Starting page 55.
Yes.
There, my lord, will kindly come to page number 57.
27.
57.
57.
57, that will be paragraph number 8 of that affidavit. That with regard to the statements made in so and so, Concerned department beg to state that Finance Department has not received any proposal from Political Department regarding granting of minimum of the pay scale in respect of the petitioner in connection with judgment dated so and so.
Just one. The petitioners are in which department?
Here it is, my lord, Political Department, Home and Political.
Home and Political. Who is representing Home?
I'm representing Lordship. In our affidavit, we have stated that the name of the petitioner was not received from the member Finance Tribunal of Barpeta, Lordship.
Where is your affidavit?
Affidavit filed on behalf of respondent number 1, Lordship.
When? Respond number 1.
Yes, Lordship. Filed
Hi,
by
yes.
Kishan Kumar Sharma. Kishan Kumar Sharma. Paragraph 4, Lordship. Stated. Moreover, the petitioner was engaged on 12/9/2008, Lordship.
Who is representing respond number 4? Member Foreigners Tribunal.
They have, my lord, the standing council Foreigners Tribunal, my lord.
Mr. Paying is there.
Yes, yes. Go ahead.
Mr. J. Paying.
Yeah, fine.
Give a notice as a scroll. Mr. J. Paying. Mr. J. Paying. SC FTC. But then we'll have to issue, we'll issue a show cause notice to the respondent before why they did not send the names.
In between, if lordship permit, so there is one another aspect of the matter. Admittedly, my lord, the petitioner hearing was appointed on 12/9/2008, and this decision has come, my lord, in 18/6/2017. As on the date of pronouncement of Upendas, the petitioner has not completed 10 years. That is the benchmark.
No, you see, where is that circular of the Finance Department?
Yes, is that
Where is that?
my lord will find a running page number 62.
62.
Yes, whereby, my lord, and this is the open circular, my lord, issued to all the administrative department, thereby, my lord, requesting them to submit the checklist.
But this can't be a this was a one-time exercise. It can't be you can't have there will be validity of Article 14.
Thereafter, my lord, after this, my lord, some matters have come up, whereby, my lord, the court has granted relief. Because, my lord, perhaps, my
So
lord,
we grant the same relief then, because they'll be entitled to that if it is 10 years or more.
my lordship will kindly say, my lord, as on the date of pronouncement of Upendas, because there is a clear direction. Upendas says, my lord, that those who have completed 10 years, they will get. Now, on the date of pronouncement of Upendas, The petitioner has not completed 10 years.
No, that is okay, but now they have completed.
So now they have completed.
You see, this Upendas is not a judgment which is made only applicable for that that set of what do you call that petitioner. So it's a judgment of the court.
Yes.
So in a judgment we can't say when it's a judgment or ratio to be applied. And when we are bound by this Jagjit Singh, then we can't say that this relief cannot be granted to any subsequent employee who have completed 10 years of service.
Yes, to that extent, my submission will be subject to correction. The Jagjit Singh was, although it is in the nature of a dictum in rem, but it was a dictum in personam. Because there, the Supreme Court took note of.
No, you see, whenever a judgment is authored by a court, most of the time it is judgment in personam. Correct, but it is the ratio which is being followed everywhere.
It is correct, I am not agitating anything to that extent, but it is my respectful submission that.
We will take account of that.
Yes.
We take note of that submission. I'll record that submission.
In case of Jagjit Singh, now export never held that they should have completed 10 years of service. In the case of Jagjit Singh, export never held that 10 years is the benchmark. But in the case of Upendas, that is a completely different issue. All the petitioners were seeking regularization. Honorable Single Judge directed the respondents to regularize their services. Against that, the state went for appeal. In the appeal, while appeal was adjudicated, at that point of time, the case of Jagjit Singh came up. And on the basis of the ratio laid down in the Jagjit Singh case method, minimum wages were directed to be paid to the respondents. So, 10 years in that set of cases, in the case of Upendas, all the persons were appointed prior to 1493. 1493 in 2017, question of 10 years was not at all questionable because they have already completed more than 20 years of service. Those persons in case of.
So what is the benchmark then? If there's no benchmark, then we put it. You see, then we'll have to tell the government to.
From this honorable court, on the basis of the case of Jagjit Singh. In the case of Jagjit Singh, apex court held that the persons who are working in the same capacity, they should be paid the minimum of the scale. As the petitioner is working as copies in the foreigners tribunal, the other copies in the foreigners tribunal, they are getting more salaries, and the petitioner is being paid only 9,000.
Mr. Segi, I don't understand. I'm allowing your petition, and then you are arguing. You see, you get it by Upendas or you get it by Jagjit Singh, you are getting the relief. What is the point in arguing the matter which the court is granting you relief? So we'll allow this petition. We'll record your submission. And
paragraph 22, for my satisfaction, if my lord permits. Paragraph 22 of Upendas.
Upendas, yes.
Paragraph 22.
We have that. Yes.
It is, however, heartening to learn that the state government has agreed not to terminate the muster roll works as similarly placed employees working since last more than 10 years, not in section post, till their normal retirement, except on disciplinary ground or on ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of the decision of Supreme Court in Jagjit Singh, also direct the state government to pay minimum of the pay scale to muster roll workers and similarly placed employees working since last more than 10 years, not in sanction post, with effect from 1/8/2017. 10 years, my lord, turning the clock back, my lord, if we go 10 years, my respectful submission, my lord. He doesn't come within the ambit of that length of service, 10 years.
Okay, we'll take note of that. Heard. Mr. I.S. Saikia, and counsel for the petitioner. Mr. R. Bopujari, and standing counsel for the finance department. First will be home, Mr. K. Gowai. S.R. Barwa, I'm sorry. Very forgetful in names. Mr. S.R. Barwa, counsel for the standing counsel for the government advocate appearing for respondent number 1. Will be appearing for 2, political B department. Mr. Barwa for 1 and 2. For 3, Mr. R. Bopujari, standing counsel for the finance department. None at present called for respondent number 4. Next paragraph. The petitioner is a copyist in the establishment of the member, foreigners tribunal within dash number Roman 2, Barpeta. Against a fixed pay of rupees 3,500 per month. With effect from 12/9/2008. Stop. The disbursement of salary of the petitioner was stopped earlier in point of time, which led him to file WPC 652 of 2012. And this court, along with other similar matters, by an order dated 14/12/2012, directed the respondent, the concerned respondent authorities to pay current as well as arrears salary to the petitioner. First, it is projected that despite a retention of the post of copyist from time to time, the petitioners were not given the appropriate scale of pay and accordingly, as the petitioner has completed more than 10 years of continuous service in the establishment of respondent number 4, the present petition has been filed under Article 226 of the Constitution of India for implementing the judgment dated 8/6/2017 passed by this court in the case of State of Assam versus Upendas and others. Citation to Upendas. First off. Next, the London Council for the petitioner has submitted that despite communication dated 21/6/2019 by the political within bracket B department, the name of the petitioner was not forwarded by the respondent before, and therefore his name has not been approved for granting minimum pay of scale as per the mandate of the case of Vindas within bracket Supra. Next paragraph. The learned government advocate has referred to the affidavit in opposition filed by respondent number 1 to project that at the relevant time, the name of the petitioner was not forwarded by the respondent number 4, and therefore his name could not be considered in the proposal for granting the minimum payoff scale. First off, the next paragraph, the learned standing counsel for the finance department has also referred to the stand taken in the affidavit in opposition filed by respondent number 3, and it is submitted that at the relevant point of time when the proposals were invited for sending names of persons who were rendered 10 years and more of service as muster roll, work charge, and casual workers, the name of the petitioner was not forwarded. First off, it is further submitted that the decision in the case of Upen Das within bracket Supra was a judgment in rem in personam and cannot be constituted as a judgment in rem so as to extend benefit of minimum payoff scale of any muster roll, work charge workers or other similarly situated employees as and when they complete 10 years of service. First off, it is submitted that as per his understanding, the administrative exercise to grant benefit of the decision of Upen Das within bracket Supra to the muster roll, work charge of his pay of the casual employees, which was initiated by the finance within bracket EC dash Roman 2 bracket close department wide communication dated 9/10/2017 was a one-time exercise, and that unless there is a government policy, the said benefit cannot be extended to the petitioner. What did you say about Jagjit Singh?
Jagjit Singh, my lord, I have checked it. Yeah, Jagjit Singh, my lord, in Jagjit Singh, the Supreme Court came to a definite finding, my lord, that the petitioners in Jagjit Singh, who were before the Supreme Court, had carried out, my lord, similar work with that of their counterparts, my lord, who were in regular establishment. Now, there has to be facts and figures in my respectful submission that if a person is claiming equal pay for equal work, he has to demonstrate before the court that, look, I am doing this work and similar work is being done by a regularly appointed person in a regular establishment. Now, to that extent, my lord, the materials are lacking in this writ petition. So there has to be a finding that he is doing the similar work. Of course, Upendra's lordship has taken a call, my lord. I will not be hesitating to that extent. But so far as applicability of the which is concerned here in this case, there has to be a finding that she is working as a copyist. She was appointed on ad hoc basis in the foreigners tribunal. Whether her the duties performed by her are exactly similar and identical to that of those performed by a regularly appointed employee in any other establishment.
By referring to the decision rendered by the Supreme Court of India in the case of State of Punjab and others versus Jagjit Singh and others, within bracket 2017, bracket goes 1 SCC 148, which was referred to in the case of Upen Das within bracket Supra. the Learned Standing Council for the Finance Department has submitted that in the said case, there was a finding returned by the Supreme Court of India that there should be a parity of pay, and that it was on the basis of the principle of equal work, equal pay, the said decision was rendered.
Yes, and the Honorable Supreme Court has categorically held that the onus of parity in the duties and responsibilities of the subject post with reference post under the principle of equal pay for equal work lies on the person who claims it.
Okay, and the onus was on the person claiming parity to establish that he was rendering the same same service which was being rendered by the other employee against whom parity was claimed. Next paragraph. In this regard, the court is of the considered opinion that the state respondents have nowhere denied that persons who were working as copyists in the establishment of different foreigners tribunal were not at all, their services were not at all, they were not at all given the benefit of fixed minimum scale of pay. Full stop. It is also not the case of the respondents that persons in the category of copyists in other establishments also get a minimum scale of pay. Full stop. Therefore, if in the establishment of foreigners tribunal in the state of Assam, if any one person who is working as copyist is granted the benefit of a minimum scale of pay, the requirement of the petitioner to prove that the petitioner was rendering similar service would not arise. Full stop. It is not the case of the petitioner that although the petitioner is working as a copyist, he should be he or she he should be granted minimum pay scale of some other class of employee. Full stop. Therefore, this is not a case where where it would be the burden of the petitioner to prove that he was rendering service similar to the one against whom parity is claimed, because the petitioner is claiming entitlement to minimum scale of pay, which is otherwise allowable to a copyist. Full stop. Next paragraph. In respect of the point raised by the Learned Standing Council for the Finance Department that there was no universal application of the criteria of a cutoff date of 10 years of service, which would entitle a person to the benefit of fix a minimum scale of pay as allowed in the case of Upendas within bracket Supra, comma, the court is of the considered opinion that that in the decision of the case of decision in the case of Upendas within bracket Supra refers to benefit being extended to those persons who at that point of time had rendered 10 years of service. Full stop. In the case of Upendas with Maker Supra, comma, this court did not pass a general order to command the respondents to extend the benefit to all the persons who are similarly situated, comma, nonetheless, the benefit was extended by the government of Assam to all the work charged. First is muster roll, comma, work charged or fixed pay employees who at that relevant point of time had completed 10 years of service. Full stop. Therefore, once the state government takes a decision to extend the benefit of minimum scale of pay to all employees who at that point of time had completed 10 years of service, comma, denial of such benefit to others who had completed 10 years of service after the said period would create an iniquitous situation which will create two different class of persons with 10 years of service but getting different a different point of time but getting a different scale of pay. So stop. In the affidavit in opposition filed by the respondent number 3, comma, a copy of the communication dated 9/10/2017, bearing number FEC within bracket Roman 2, bracket closed, 4/2014, topic 365 by the Commissioner Secretary to the Government of Assam Finance Department. Which is issued by the Finance within bracket capital EC bracket dash Roman 2 bracket department is annexed. Full stop. Although in the said letter, comma, the particulars were invited not later than 31/10/2017, but the said communication cannot be read as if the granting of minimum scale of pay to the muster roll work charged, fixed pay, casual workers, etc., was only a one-time exercise. And thereafter, the said exercise was disbanded. Not disbanded, it's called, was withdrawn or revoked or cancelled. Next one. Therefore, comma, the court is inclined to negate the submissions made by the Learned Standing Counsel for the Finance Department, and qua the petitioner, comma, the court is inclined to hold that as the petitioner, as other similarly situated copyist in the establishment of foreign tribunal in the state of Assam. Some of the have been granted the benefit of minimum scale of pay by following the ratio laid down in the case of Upen Das within Begar Supra, the petitioner is also found entitled to the same benefit. Next para. Accordingly, this writ stands allowed, directing the respondent authorities, jointly and severally, to
May kindly direct my lord, the respondent number 2 to submit a proposal to the respondent number 3.
Okay.
Who will be the commissioner and secretary of speed up the
specifically to the respondent number 2 to send a proposal to the finance department for extending the minimum scale of pay to the petitioner within a outer period of 1 month. This proposal will come to you within 1 month.
Yeah, 1 month. No, because my lord, the Home and Political Department will have to get the inputs from the finance tribunal. So 1 month, my lord, and then within next outer limit of 1 month.
Okay, within outer period of 2 months, which includes time for interdepartmental communications, and thereafter, the respondent 2 shall forward the proposal to the finance department for approval and sanction.
For approval and sanction for complying with the directions.
Sanction in terms of this order.
Yes.
In terms of this order, first stop, the benefit of minimum scale of pay should be provided to the petitioner within the outer period of 4 months from today.
Yes.
So 2 months for communication and then 2 months for you.
Yes, yes. There's a not many time.
It should be given up when this has completed 10 years of service.
No, this will be from from the date you file.
1/8/2017. That was the other person submitting.
No, this we won't say. This is petition was filed in 21.
21.
We can't give you a benefit prior to that. Huh? From the date of filing. This petition was filed on 14/10/2021, 12/2021. Therefore, the benefit should accrue to the petitioner from 14/10 to 14/12/2021, the day he approached this court.
Let's petitioner furnish a copy of my lord's order, my lord's order to the
Okay.
Home and Political
The
Department.
petitioner,
Within 1 week, my lord.
the petitioner shall serve a certified copy of this order on the respondent number
It will be respondent number 2. my
2,
lord.
on the respondent number 2,
Political-
within a week from
Yes,
today.
Yes, this will speed up the process.
Next, in the meanwhile, the Learned Standing Council for the respondents shall also send a downloaded copy
Yes.
of the order to the authorities
Absolutely.
as advance information.
My lord, my lord.
In number 2, this second item, you are doing what? You are also copyist. Same order. Okay, so in the order, anything is required to be changed? No, same.
I have filed my application of which number 156, item number 9.
No, I am asking you a question. Your file is with us. We are asking you a question in the order which I have dictated. Is there any changes required to be done in your case, except for the foreign tribunal name?
No, my lord, but
No.
respondents may be referred.
Okay.
Then it should be mentioned in the order to whom direction should be. And I have filed my petition on 9/1/2012 in case of the petition number 186.
Okay, why it is pending for so long?
Well, my lord. Here, my lord, he is only seeking release of area as well as current salaries.
So why it is pending for so long?
Perhaps, my lord, this needs to be segregated, my lord.
My lord, a launch of order has been passed earlier.
Or is it?
Here it is not, they are not claiming, my lord, minimum pay scale. They are, my lord, claiming, my lord, area as well as current salaries.
Prayer may not be there, but still, but we'll have to give you an opportunity. Once we grant that relief, before that, we'll have to give you an opportunity of contesting that.
Yes, my lord.
His claim is for regularization.
Yes, regularization.
Okay, you are still not getting the relief. We'll give them an opportunity. Mr. D. Bora, counsel for the petitioner, Mr. Our representative for the finance department. Same set, same orders. So and so for next para. Who's appearing for Accountant General? Mr. R.K. Talukdar. Mr. R.K. Talukdar for respondent 6. Here CGC is also there, Government of India.
Yes, my lord.
Mr. Bora, you are appearing as CGC, no? No. Mr. KK Parashar for respondent 1. Chief Secretary and Home, Mr. S.R. Barwa. You are there? Mr. Ardhar for respondent 2 and 3. Finance is Mr. 4 is Mr. Barbujari. 5. Mr. Pang is not there. Nanak is. You have Mr. G. Sharma, standing for respondent 5. R.K. Talukdar, Learned Counsel for respondent 6. You record his presence in the first case also. Foreign Tribunal, Mr. G. Sharma. In this case, the petitioner is seeking a relief of regularization of his service in a vacant sanction post. Full stop.
My lord, in the affidavit, my lord, the contrary stand they have taken, my lord. In the affidavit, my lord, filed by the respondent number 3, my lord, in this matter, my lord, at paragraph number 4, it has been stated that there was no post of copies in the office of Foreigners Tribunal was lying vacant at the time when the petitioner Siddhartha Das applied for the post of copies. And then, my lord, at paragraph 8, my lord, stated that the petitioner submitted a representation before the Commissioner Secretary of Home for the post of bench assistant. But it is also a fact that 4 numbers of copies have been engaged as stated in the writ petition, but this engagement was done purely on temporary basis and fixed. However,
That's why you're not going into those things. What we are doing is that you just hear the order, then you'll understand what I'm trying to say.
my only apprehension is that, yes, principal error of petition, only my lord.
No, I'm not allowing the petition. You just hear the order.
Here, my lord, some verification will have to be done.
No, this is okay.
Because as on date, whether he is working on.
We'll give you the handle. Don't worry.
Yes, my lord, that works.
Petitions for regularization suspension service. Full stop. However, prima facie, it does not appear that the petitioner was appointed by following due procedure of law relating to the employment in public, relating to public employment. So nonetheless, the court finds that if the petitioner has rendered 10 years or more of service comma,
I have joined on
he would be entitled to the benefit flowing from the ratio of the case of benefit from the decision of the case of State of Assam and others versus Upendas so and so. Full stop. Therefore, comma, the respondents are put to notice to respond as to why the benefit of the ratio laid down in the case of Upendas shall not be extended for the petitioner. Full stop. In this regard, the respondents are at liberty to make an inquiry as to whether the petitioner has been rendered service since the date of appointment and to file an affidavit if so advised. Next para, list after 4 weeks. Just add one more line. I forgot one line. It is a question that not been for public employment. Therefore, privacy does not appear that the petition can be entertained for the relief of regularization of service. First of all, however, this is only a tentative view and not a finding of fact, which would not prejudice the petitioner when the matter is heard. Then, however, so and so.
Can you specifically direct only the respondent number 3 hearing? Commissioner and Secretary Women Political.
No, I've said all. Anybody can make an inquiry, whoever wants. If the finance wants a clarification, you can also ask for clarification.
Member also a party.
Member tribunal can also do all the respondents. I'm not restraining to 1 and 2. But tomorrow finance will come and say that you did not give me liberty. I did not make inquiry. Now I will need 6 months time to make inquiry. Not that.
Yes.
So since I'm holding the relief, I have recorded in the order and then so that he can get the benefit of Upendas. Mr. Bora, you followed the order. Regularization, if your prayer is there, we'll have to dismiss it. So we are molding the relief and they will make an inquiry.
I'm still working.
No, it's okay. We are not disputing that.
But they have issued a cancellation letter earlier. We have filed miscase, etc. The long learned litigations.
What is the that miscase is not here.
Miscase is.
You might not maybe please to take up the affidavit of R3. It is already there. R3 para 30.
Complete. Eyes are disposed of. So, no point looking at that.
No, my lord. Only one says he has agitated.
If my services they have found I am still working, my lord, then my service may not be disturbed.
No, I am not passing any interim orders. For that, you file an application. In a writ petition, I am not passing that order. Now, which is the third case, Banashri Kalita?
She is also petition.
You are for her also? To regularize your service, same order. Here you have to add one more thing. The second case, the person is working at in the establishment of member Foreigners Tribunal, Kamrup Metro. In the third matter, the petitioner is a lady. She is working in the establishment of where? Foreigners Tribunal? Where? Tinsukia. Okay, member Foreigners Tribunal, Sivsagar.
Earlier she was Sivsagar, then That furnace superintendent has been relocated, my lord, and then she is working at still continuing.
Earlier, are we working in foreign member, foreign establishment of member, foreign established Simsagar, and thereafter relocated in the establishment of member, foreign tribunal Tinsukia. Same thing. Okay. 4 weeks time, same order.
Item 21.
Ubindas judgment বেলেগ ৰাখি দিয়ক না আমাৰ দৰকাৰ হৈ থাকিব Ubindas মানে এটা লাগি থাকিব
In this case, my lord, after the date of the husband of
just a moment, give me 2 minutes. Yes, family pension.
We've already submitted the pension proposal as well as the service.
You have to speak a little louder or shout.
Am I audible enough?
Yes.
Lordship, we have already submitted the pension proposal as well as the service book to the director of pension.
When?
6/7/23. That is there.
6/7/23. Show me that instead of finding me finding it out. Show us that. Who's appearing for education department? You are there. Mr. Sharma, you are appearing for education department. You have to get us instructions. No, this has gone from the office of inspector of schools to the director of pension. Oh, acha, from director of pension. Yes, Yuri.
I shall obtain a copy from her with regard to the same.
You take this copy.
Yes, sir. And
You give me a copy.
Shall be uploaded.
Mr. S. Das, counsel for the petitioner, Mr. P. N. Sharma, done as standing counsel for the Department of School Education. No, you are appearing for school education. Miss. Name? V. Troy. Shoy. Yes, write it down. Then standing counsel for the counsel appearing on behalf of standing counsel for KAAC. Mr. B. Theory.
For respondent number 9.
The standing counsel for respondent number 9. And Mr. R. Pujari, standing counsel for finance department. Huh? Appearing for treasury officer. Next. Name? J. Das for respondent number 4. Next. Mr. S. Das, done counsel for the petitioner. No, sorry, the counsel on behalf of the KAAC has forwarded has produced a copy of communication dated 6/7/2023 from the Inspector of Schools, Karbi Anglong District Circle, addressed to the Director of Pension Assam, by which the pension proposal of the petitioner was submitted. Full stop. The learned government advocate appearing for the director of pension has been provided with a copy of this said letter, so as to enable him to obtain instructions from the director of pension Assam about the status of the pension proposal of the petitioner. Next paragraph. The respondents are put to a notice to take it may be stated that in the writ petition it has been projected that the husband of the petitioner was working as an assistant teacher of Vivekananda ME School, Bokajan, under Karbi Anglong Autonomous Council since 12/9/1965, and that he had died in harness on 5/6/1983. So therefore, the pension proposal is now, which is now being processed, is about 40 years old. So therefore, the respondent authorities shall take note of the inordinate delay in granting of pension to the petitioner, and therefore the pension proposal should be expeditiously processed. Next paragraph. The court expects the director of pension, Assam, to provide updated details of the status of the consideration of pension proposal of the petitioner before the court on the next date through their learned government advocate. Next paragraph. List on. Give a fixed date after reopening. 4 weeks. They're giving you this copy.
Yes, Your Lordship, and copy perhaps will come.
The next paragraph. The learned government advocate shall send a downloaded copy of this order to the director of pension.
10/11, 10th of November.
Just give him a copy.
Item 22.
During the pendency of this petition matter, the authorities, Inspector of Schools, have passed the order regarding grant of a third MSCPS repetition.
You've been given.
This order has been passed, and some corrections with regard to service book entry has been made. But now the process of preparing the statement of this area salary.
They'll give it in due course. We'll close the repetition then. Once they have.
Let it be there by this time.
No point keeping it pending. If they have done so much, you think they will withdraw it? Do you doubt you're not actually serving?
Your Lordship, dispose of with the direction to expedite the
I will do
process.
it. How much time will you need to complete it?
Lordship, some time will be required, Lordship, 2 months, Your Lordship.
We give you 3 months.
Yes.
Instead of 2, you are wanting 2, we give you 3.
Lordship.
But do it within that time.
Then service benefit and the pensionary benefit will be revised accordingly. On the basis of the
The consequential benefit, we don't say anything. We don't say what to do. You'll get a consequential benefit once the third MACP is granted to you.
And the correction of the.
Where is the communication of this?
Lordship, provided the petitioner, he has to give the required documents.
Yes, of course.
If it doesn't give, cancel it. You give in your letter that you do it within so and so time, otherwise we'll revoke it. And you'll find it comes to you. Correct. Government knows the means of arm twisting. Do it.
But one thing that I want to show you, Lordship, from the page.
You see, once I pass an order to that effect, then you will say that you have given him a letter, you show us copy of the letters, this was sent. Then we ask you to provide your peon book, then you will provide a peon book. This is served to one person whose signature is illegible. So we enter into that dispute. Don't do it. Take an email address, send by email. No, what you call, and if he doesn't send the replies, revoke it. Pass a conditional order and revoke it.
My lord,
Yes.
I want to take you to page 33. Page
30?
33.
3. Yes.
In this case, my lord, this is the order of the regarding grant of an MSCPS two benefits, my lord, with effect from 1/1/2011. And my lord, what has, my lord, wrongly happened, my lord, in page 37, while entering into the service book, my lord, it was benefit 18,720 was given from 1/1/2011, but it is, my lord, made 18,170 from 1/1/2011, and there's the wrong error.
No, then we got to put a notice. This can't be corrected in order summary disposal. Then we give you notice, you respond to it.
They have corrected as per instruction of my client. that
No,
is
no, no.
corrected.
You see, the orders which I am proposing to pass is only a plain simpliciter orders. If I have to pass an order for corrections, then I have to ask an affidavit from them. Why this error has arose? What has happened? So these are not on summary disposal. I am not giving those directions.
They have corrected. I've been told by.
No, no, no. If you have got the relief, you got the relief. If you want something from the court, then without a response from the respondents. No, I am not in summary disposal. I am not giving any conditions, which leads to what you call discrepancies in calculation.
Yes.
No, no, that is not going to happen in my orders. I pass an order, then they do the calculation, then they make some mistake, then you come again in contempt. And I'll be the one who's be burdened with hundreds of orders. No, no. Then you file a response. Mr. V. Purkayas, the counsel for the petitioner, and Ms. I forget, D. Musari, standing counsel for the education department.
Seconded.
No, now it's only school education department, one department, school education department, and Mr. R. Borpujari, standing counsel for respondent number 5. And Mr. B. Diori, government advocate, appearing for respondent number 6. Next para. The learned standing counsel for the school education department has produced a copy of communication dated 4/10/2023 to inform the court that the necessary approval has already been given for granting third MA CP to the petitioner, but some process are due for giving the consequential benefits, for which he prays for 2 to 3 months time. Next para. Accordingly, the competent authorities of the school education department shall process the consequential benefit accrued to the petitioner on grant of third MSCB during the pendency of this writ petition, and the pendency of the writ petition shall not be a bar for the respondent authorities to provide consequential benefit to the petitioner. Next para. The learned counsel of the petitioner has referred to the copy of order, next is page 33 of the petition. The project that there is some calculation error. Full stop. In this regard, the respondents shall file their affidavit in opposition in the event they desire to contest the said claim of the petitioner. Next, the pendency of the petition shall not be a bar for the respondent authorities to examine the claim of the petitioner of calculation error creeping in Annex 3 to the rate petition within bracket page 33 onwards. Next, this after 4 weeks.
Item 23.
Just a minute, Mr. Barai. Mr. Barwa, just a minute. Yes, you filed your response, Mr. Bundi. What's your stand?
Yes.
What is your stand?
Here, we have in our affidavit, we have given the calculation method, and other aspect is along with the petitioner method, there are other employees who are due for the crossing of the efficiency bar benefits method. For that matter, the board has to place the supplementary budget, which is being prepared method, not yet placed. Only after the clearance of the budget method, the benefits shall be paid to the employees.
That means we have to wait till February.
They will, the budget is not yet placed.
No, I understand. Budget means 24 budget.
Not the yearly budget, but supplementary budget.
Supplementary budget has already expired. Time for supplementary budget is gone. Mr. Varpujari, what is the normal time when supplementary budgets are taken up by the state? I think it's August, September. Or it's still open? No. In November it will happen again. Oh, okay. No, that's why I'm asking you. Okay. So we adjourn the matter to give them some time.
Here question will come, suppose and also is coming below. That part will be come later. Why? Because they have by affidavit, they have some to be drawn 32 lakhs 10,000 rupees. According to area. Then less already drawn 23 lakhs 65,000 375 net pay so and so latest. Here, my lord, I have inquired from my client that particular drawn already drawn. That is been not been, he has not done this amount, you know. That is why now last order also last honorable court was pleased to place the how it did pay. That is not paid. It is my affidavit is that why I am asked to file affidavit reply.
With regard
Then
to that,
reply.
how amount is paid, madam, that
Reply.
we have placed any instruction, madam, that is on record.
That is why I am very much agree with my learned friend. That is why I have denied this amount. That is why I have clearly stated in short a reply that let them prove this what manner. If they have really paid, what manner it is paid to 23 lakh to me. Because still they have to pay me 23 lakh. That is why I have filed a reply, my lord. That's until and unless this record comes or clarification on properly. That is why last occasion also honorable court.
We file an affidavit, deny it.
I deny it. This is why it's to be brought on record for answer justice too.
Okay.
Because otherwise, my lord, if funds also coming, how they will pay? Because it is not calculation is not proper according to me. That is my anxiety, my lord.
Okay.
Otherwise,
Okay. You prefer to speak to each other in court, not in the office. In office, you can't go to the office and officer and tell him that this is the This is the difficulty.
It is because we learn lordship. I also requested him. He is a grateful employee. He is whenever he is coming. Okay, he's been paid. No, not giving proper record. That is why I am before your lordship. Otherwise, I
No, that is okay. If there is a calculation dispute, why can't you go there and speak to the concerned officer in your own office?
He has gone. I have asked him to go, but he's not been punished. Okay, you have been paid this much, this much. That is only problem.
Okay, then speak in court.
That is why before your lordship. That is an other.
Both sides have been represented. The learned counsel for the petitioner, praise for is granted 2 weeks time to file the affidavit in reply. Then you.
Already
It's not a record, they have filed yesterday.
Okay.
Very important record.
Okay, then.
My here I have denied that let them show me 23 lakhs what many it has been paid to me. That is my anxiety, my lord. That's why this sort of.
Where is your affidavit?
Affidavit I brought on record today by mentioning.
Oh, no,
Otherwise, I can keep copy. On record it is what? Lordship got it ready. Para 4, here I am, but it is to be stated again. Fine, I keep it.
I think in this 2 minutes time which I have read. In this 2 minutes time which I have read, subject to correction, if I have understood it correctly, you see, when you cross efficiency bar, how much salary difference do you get? 100 rupees, 200 rupees, 500 rupees? No, don't explain it. Just tell me, how much in the efficiency bar if you cross, how much financial benefit will accrue to you? 500, 600, 1,000 rupees? Correct? You take it 5,000 only? Highest point 5,000 you are getting the area benefit. How many months have crossed after the efficiency bar?
It is 2003 onwards. 2003 to 2021.
3. Just not just make a calculation. Take out your mobile and do the calculation.
No, because they are own calculation.
Just do that exercise. I have a reason to tell you. From 2003, you cross the efficiency bar. Can't be.
That is correct. You pay for September 2003 to July 2021.
So, you cross the SCM for the period to 21. So 18 years.
That is their own letter.
No, 18 years. 18 years into 12 months is how many months? 96 months. Correct. 96 months into the efficiency bar benefit is how much? I think here it is 40 rupees, 60 rupees, 90 rupees. So let us take for an example, you get 1,000 rupees. Here it is said efficiency bar is after that you get 60 rupees more. So we take it that you are getting 1,000 rupees more. Correct. 96 months into into 1,000 is 96,000. Correct.
That may be correct because.
No, I'm just giving you a rough estimate. Then in their affidavit they say you are entitled to 32 lakh rupees.
Yes.
Out of which your salary already drawn is 23 lakh rupees. So the benefit of
Less already drawn.
so you see, for 13 years, if you cross efficiency bar, will you get 23 lakh rupees?
No, that is why we record.
I understand you, but that is why not that is why this is not the question. When you cross an efficiency bar for this 18 years, will you get 32 lakh rupees? You do the calculation, you make the calculation.
That part is also paid by them only.
Now you take out the calculator. 32 divided by 96. 32 lakh divided by 96. How much it is there? 32 lakh divided by 96 is how much? $33. So therefore, in addition to your, it's okay, Mr. Barwa, after you cross your efficiency bar, your salary, which is otherwise in the scale of 2,450, every month you will get an addition of 33,000 rupees. That is your calculation.
No, this is not my calculation. Calculation given by them.
I have told you, I have explained you the calculation. If you take time to understand it, you are rightly in grade 4.
No, because that also this one question is
You see,
definitely come. But the respondent number 2 has calculated and given to the.
he is. That's what I have understood.
Otherwise-
If I can understand and you can't understand, you litigate. We will fix it after 2 months. If you want to litigate, you litigate.
After, no, let them, whatever it is bond record, this one say.
I have told you, if you don't want to understand, I can't force anything into you. So you see, you are a run counsel. If you can't understand the court, nobody can make you understand. Your salary is in the scale of 2,600 odd rupees. Efficiency bar you cross, you get 60 rupees more. And they are saying you have got 32 lakh rupees is your withdrawal amount, out of which 32 lakh has been paid to you, which is your regular salary. So there is only the difference of efficiency bar which you will get. And then if you want calculations, let them give calculations within you give an explanation.
Yes.
Take 4 weeks time. What is it, President? The counsel for the respondents face for granted 4 week time to respond suitably to the affidavit in reply filed by the petitioner. So it's an unnecessary litigation. You can even a grade 4. You do one simple thing. You ask him your fees. Ask him your fees of 20,000 rupees, and he will tell you, sir, you have asked me for fees of so and so. I have paid you so and so. So he'll know the calculation when you ask your fees. Tell him I'm on live. So tell him the court has asked me to quote abnormal fees, and he'll tell you what is the calculation.
Because of anxiety has come because calculation has come there. That is why. Let us
At
see
least
the-
you have some sense. At least you have some sense, Mr. Barwa. Why you are litigating for a unnecessary cause? Efficiency bar, you are asking merely for efficiency bar. Can efficiency bar lead to you to 33,000 rupees enhancement of pay?
No, that is why we are praying for Vivek clarification only. because
Why you
this is
need it?
Vivek
You
clarification.
do the calculation. I am making you
No,
a
that
calculation.
calculation because that's what
No, no.
calculation. That
It's
is why
an
we want to
unnecessary
know this
litigation.
things.
It's a unnecessary litigation. It's a lawyer's paradise. This is not for your client. The next
No.
item.
It is, let them, we are praying for this one. It is a court's order only, we have paid this one. They have given initial.
You
one,
see,
they asked me to file affidavit.
money is
Anyhow,
something I will understand faster than you.
Maybe.
And that is, if you cross efficiency bar, 33,000 you are expecting.
We are only
You are living
paying
in.
for, let them give a calculation, what is the trouble for them to give it, what they have calculated, let them.
He's
give
not
it.
asking for time. He's not saying there is a difficulty in giving it.
No, this is why I only prayed to affidavit opposition only paid. I have but it's submitted.
It's okay. Next item. I passed the order. Next item.
Release, my lord.
Item 24.
Yes. Just a moment. Just a moment. Yes, what is your stand?
Lordship, we have received complete instruction, Lordship. The petitioner here has been accommodated as to teacher, Lordship, and he has with the prospective effect, Lordship, and accepting the terms and conditions, Lordship, the petitioner has been accommodated and he has already joined, Lordship, and even he has furnished his undertaking also.
Then file an affidavit.
We will file it.
How much time?
Lordship, after petition.
This is non-receipt of salary. Give a fixed date after vacation. Both sides are duly represented. Mr. P.N. Chaudhary, counsel for the School Education Department, submits that he has received instructions and would be and prays for and is granted 4 weeks time to file affidavit in opposition in the matter. List on after 4 weeks, give a date.
14/11. 14. Item 25.
Yes, Mr. Sarika.
So in terms of order 21/7. No, 1 and 4. Directed to file activity. Matter pertains to minimum pay scale granted.
That is a board. You may not get it. You have to file a response in this matter.
We are awaiting the response. We have communicated to the department. But my lord, admittedly here, my lord, he is an employee under the board.
No, that's why I'm saying that. No, this I understand, but you'll have to file your response. It's a 22 matter.
Even if my lord file, my lord, we will be only limiting our affidavit. But
No,
now
no.
we have received
You
any
see, it's
proposal.
not a question of who is doing it, but once somebody is there with the court in 22, we are now in 23, end of 23. So either they voluntarily file an affidavit, or we give them space where Mr. Deori is sitting for them to come here and work. If they want to come with the files here and work, we'll just request Mr. Deori to shift his chair. No, not now. When the officers come to work here, we'll ask him to shift his chair for 1 by 1 feet. How much time?
Let us fix this matter.
We give you 4 weeks time, but then you file it.
We have already communicated, my lord. We will send a reminder.
3 and 4 and 5 file it.
Yes,
The board has filed it, my lord.
Huh.
Now, my lord, the administrative department concerned, my lord, handloom and textile and finance.
Okay, all sides are duly represented. Mr. R. Bopujari and standing counsel for the finance department. Appearing for respondent number 2. Praise for is granted 4 weeks time to file affidavit in opposition in the matter. List after 4 weeks. Make a mention if it is not listed.
Item 2733.
Lordship, before starting my understand, in this case, Lordship, one affidavit in opposition has been filed by government Lordship. I have received copy today. Lordship, let me give 2 days and I will get back with some instruction so that matter can be disposed of, Lordship, on the next day.
So just let me understand what is the affidavit.
Affidavit has been filed by the PWD Lordship. It was filed yesterday. Lordship, today I have been told Lordship annexure one of the affidavit has been some objection. So we are looking for a fresh copy.
In affidavit of there's an objection of annexure 1.
Tomorrow I will get the fresh copy. It will be provided.
Okay, so we give them time if they filed with defect.
My lord, in item number 28, then 29, 30, 32, and 33, I have filed an impleadment application. My lord. We are the successful candidates. We have been selected. We have already appeared for Viva. Now we are waiting for our results. Due to the pendency of these kinds of petitions, our results is not declared. And my lord, this is a right which is claimed against us. Altogether, 92 posts have been stayed, my lord. So my lord, it is affecting us also. And
Okay, where is that IA?
my lord, IA in page in item number 28, my lord.
That's
It is IA 2866.
Yes.
That is item 28, my lord. Item 29, my lord, it is 2853.
Okay.
Then item 30.
Just a moment. Who is appearing for the writ petitioners? You are there, Mr. Das. Oh, okay, you're all there. Any objection to this?
Lordship, we have some objection, Lordship, because Lordship is just a shortlisted candidate. It's not a selected candidate. It was shortlisted. Viva appearing in the Viva process doesn't give you a guarantee that Lordship will be selected. Lordship, there is a 307 posts and more than.
No, that is okay. Good enough. You see, we take it as an objection and we reject the application. Correct. But we say that there's you can't be entitled to any relief which he is being processed, and therefore his selection may proceed.
Lordship, there is a suppression also in this IA, Lordship.
No. You see,
Lordship, the same the affidavit that has been signed by the that Mokidul staff. He has filed a repetition also, Lordship. That is not mentioned in the IA.
Item 26. Mokidul Islam. I don't know about others. He just pointed out. I don't know about it. Now, in the repetition, he files the repetition, saying that we only want the results. We only want the results. Because of this litigation, our results have been blocked. So, with only that prayer, I filed the repetition. Now, I don't know about this IA. Now, he again files an IA for impleadment in other repetitions also. Yeah, but that is the case.
no, it's a simple query of the court. Number one, you see, somebody wants to be impleaded,
Yes.
and he says that he is also a candidate who has been called for Viva. Correct. If you don't want him to be involved in the writ petition, then we give a clearance to the government to process their applications. You have nothing against him.
Yes, my lord. On earlier occasions, we have already submitted that we have no objection from that because we have only challenged the.
Okay, correct.
Government has some
problem. Because if he becomes selected, Lordship, then again the whole roster.
No. Because you see, if I am passing an order, I'll make it sure that you infringe on his right. It is his IA. You are objecting to it. That means he is not a necessary party. If he is not a necessary party, in writ petition, no order can be passed against a non-necessary party. As simple as that.
For an illustration, Lordship, if I get the 50 marks out of 100, and my process will get taken, Lordship, with regard to my. And if the selected candidate who appeared in a Viva,
He gets it. You see, you get an opportunity to impede him, and therefore the interim order passed is binding on him. once he is not a party in the writ petition, that your interim order is not binding on him. Yes. So you take a situation, you change sides. Now you come to the place of Mr. Khan, correct? And you file an application for impleading. There's an interim order operating, correct? Now tell me simple thing without without the party, with the interim order operate on him. If not, why will a order staying keeping one seat vacant will apply on him then? Yes, any answer to this query? We can give you time to do it, but since there is an interim order operating, do it. You file your objection within a week. And technically, I'm telling you.
And we are not objecting. I am not objecting. Just clarify, because he was the writ petition in 26.
Because only when you allow his impleading, under subject to correction, I am not saying that I am an authority on the point. But what I am saying is that going by the civil principles of what you call pure and simple CPC, an interim order which is passed in absence of a party will not be binding on it. That is the principle which I'll follow. No, that's okay. But now he is before us. Now he is before us. He's saying that he has a say in this writ petition. Now, if you exclude him, that is with consciousness. Till now, you may not know who will be the affected party. We can have that excuse. But now you know, today when the application is filed, you know that he is an affected party. And then you object. So instead of giving you time to object, we'll record your oral objection and pass orders. In a writ petition, technically it will not come in the way. So if you object, we'll record your objection. Even without a pleading, we'll record your objection. So take your choice. We give you time, 1 week's time, you file an objection.
Ultimately, whether he has a right or not, that is the question.
No, he doesn't say he has a right. He merely says that he has a right to be present in the writ petition. He is not filing a counterclaim. In a writ petition, there is no counterclaim. So even if he is a party, what at best, what can he do?
He doesn't spectator performer.
He is a spectator. He can be an intervener. He will be a spectator in this case. He can watch that. He can keep a watch whether his rights are taken away by the order of the court. No, I give you time. I'm not imposing myself on you. You take a call, but I'm giving you the reality situation. Because you will be more. Because if this bench is taking up, there will be more trouble than. Okay. All sides are duly represented, including Mr. F. Khan, learned counsel for the petitioners in the interlocutory applications, connected interlocutory applications. Next para, the learned counsel for the petitioners praised for and granted 1 week time to file objection to the impleading application, if any. Full stop. List on. Next Friday we will take it up. Today is either Friday or on Monday. When do you want?
Next week to do better. Because my lord, if possible, my lord, we were looking forward that if this batch of petitions could be disposed of before the Puja vacations.
We don't know that. That is. No, I understand, but you see, today I can't commit when there is nothing on record.
Because my lord, affidavit has already come, my lord. So my lord, it has.
No. You see, he has to correct his affidavit. There is a defect in his affidavit. Next paragraph. In the meanwhile, Mr. P. On the prayer made by Mr. P. Nayak, standing counsel for the PWD, he is permitted to rectify the defect in the affidavit in opposition filed by the PWD in the meanwhile, with copies to the appearing learned counsel. List on next Monday. Monday holiday. It will be
9th October.
no, not 9th. Today is 6th. 9th is not possible. 16th is a working day. Or 13th. 13th is it next Friday. 13th. 13th. 10th.
13th.
Okay.
I'm grateful, madam.
Yes, Mr. Deori.
With regard to item number 21, Your Lordship,
Yes.
the matter was since it is 40 years back, Your Lordship. Just I communicated them, and instantly they forwarded me a communication which was made to them on.
Oh, that is very fast.
Somehow they
It's very fast. Wonderful. In fact, your efficiency must be whether it is positive or negative is something else. No. You see, question of positive or negative being another thing, but your efficiency must be acknowledged. Okay.
I shall forward it to Kathmandu Standing Council and the petitioner. So it will be a step forward.
Okay. Okay, that is wonderful.
Item 21.
Item 21. কোনে লৈছিলে? আপনি লৈছে না? 1921. Later on, Mr. B. Deori, a government advocate, has obtained instructions in form of a communication dated 12/9/2023 from the Directorate of Pension, informing by which the Inspector of Schools, Karbi Anglong District Circle, DIFO, has been informed that as the proposal for pension has come after a lapse of about 40 years from the date of death of the pensioner, the said authority was requested to move the government in the capital ARTP symbol and PG department for relaxation of rule 205 and 206 of Assam within bracket service bracket close pension rules, 1969. And accordingly, the pension proposal in original was returned. Full stop. The learned counsel for the petitioner shall take note of the same. Next para. The copy of communication forwarded by the learned government advocate is kept as a part of the record. Please communicate. I'm not saying. But really, this is wonderful. In my experience, this is the first time it is happening.
Item 34.
During this matter, Lordship, may I
And he's a good environmentalist. He does cycling daily. I've seen you many times cycling for good health. Yes.
Here in this matter, Lordship, I have received instruction, Lordship, the affidavit has been sent for vetting, Lordship. It will be filed by Monday, Lordship. Can it be taken up on Wednesday, Lordship?
Wednesday. Sorry? 11. Okay.
Can it be on 13th, my lord? 11. Can it be 13th, my lord? Friday.
Friday. Okay. Both sides are duly represented. Mr. D. Upamanyu, Standing Counsel for the Higher Education Department, press for time till The praise for 3 working days time to file affidavit in opposition in the matter. First off, list on 13/10/2023. 3 working days I have said.
Yes. Item 35.
Bail application for third fellows. And
Okay, what is the offense under which section?
Section 120B, 302 of IPC and 25(1)A, 27(1)B of armed sector. And I was arrested on 21/5/21. Today is 866 days.
866.
Your lordship had dismissed our petition lastly on 23/1/23.
Okay, which page is that order?
This is page number 76.
73.
76.
76.
Trial
Trial is going on.
Trial
Trial
to
not-
start.
Not yet started, my lord.
Not yet started.
My lord, yes, my lord, I have gone to the LCA, my lord, there are 4 branches in the LCA, my lord. Last date of my lord, here, my lord, order, my lord, dated 8/8/23, still in the stage of my lord appearance. My lord, you.
After obtaining bail from all other co-accused, they are freeing away from justice. They are not evading the process of trial, freeing it. Still obtaining bail from, they are all habitual offender. Because, my lord, both of said.
No, no. For others, we can't say right now. It will be improper to comment.
Still in the
But-
stage of my lord appearance, still.
No, but then,
He is the main culprit, my lord.
no, but you see, without trial, if it's for 860 days, he'll be entitled to bail. Even if it's even if he's objecting.
But
Even if Mr. Ahmed objects.
one fact of the matter is that Malat, these person, even the disease and the Malat, accused all are Malat, involved in Malat narcotic drugs business, Malat. And business during the business rival, Malat, this thing happened, Malat.
No, you see, whatever happened, he according to the case diary, he is the person who was shot dead.
Yes.
Correct. There is no dispute with that.
Yes.
He is shot dead. But despite that, if the trial doesn't start, you see, you are the prosecution. You will have to request the trial court to segregate and start. If the trial doesn't start, we'll have to give him bail.
Yes. Because of the person not appeared, because of that. Malat.
No, because you see, if this person doesn't appear for 2 more years, then what happens? You can't be in jail for perpetuity. 866 days is 2.5 years.
Last date. But still,
Mr. Ahmed, you are for or the informant.
still pending in the committee.
Cases of whatever information I received, my lord, case has been split up. It was a freeway from justice. They are not appearing regularly, so case has been split up. But this present accused is concerned and 2 more accused. Now they are perhaps, my lord, they are facing trial. With other accused concerned,
No, I understand, but you see, somebody is not appearing, for which can third party be kept in jail?
no, this is my side, also you must decide, but the thing is that, my lord, they are all habitual offender. Only accused person, my lord, is Sampad Bhomik. Immediately after obtaining bail, twice he arrested in trafficking of narcotic drugs. His younger brother, Bottom Sen, immediately after obtaining bail from the Honorable Court, arrested on 14/2023 in connection with trafficking of narcotic drugs and arms. And one accused, my lord, Santosh Chauhan, he was arrested in UP, Uttar Pradesh, in trafficking narcotic drugs. Habitual offender. So this petitioner is concerned, my lord, they were sold out entire.
No, no. For this petitioner, what do you have? We are now concerned with Mr. Sen, Suraj Sen.
Yes, Suraj Sen, my lord. Suraj Sen.
What is there against him?
He's the person who shoot the my lord, the victim, with an unlicensed pistol, my lord, pointing for his forehead, which resulted his death.
From the zero point minute, 0 point distance, and eyewitness also in the fourth, there are 4 parties. I also check mark that eyewitness also there, in presence of the eyewitness.
This is their allegation, Lordship. I am ready to face the trial. If I come out from the jail, I am ready to cooperate with the trial, Lordship. I am not taking over the trial. I am the permanent resident of Hosai. I have my own land. So, Lordship, the bail is to face a trial, Lordship. If Lordship is satisfied that I will face the trial, I may be allowed to go on bail, Lordship. At any condition, I will face the trial. And if they are
Then you file your affidavit and produce the land documents.
Lordship,
That remains, my lord. He has sold out his entire property from Gujarat. Now here is the property already sold out.
No, you see, these things you have to file an affidavit. Tell us
definitely, Lordship.
the surety, because if we can give surety, and you are saying that the land is sold out, you will have to give something before the court.
Yes, fine. Then I will file affidavit. Sometime maybe given, then I will first I collect documents, then I have to file.
If he has no document, he has no any authority, Lordship, then this submission cannot be.
My client
cannot
has.
be-
No. You see, when a learned counsel is making a submission, we will take it that he has got instructions. He may not have documents. You see,
Let him file objection.
you see, let us say X. He shifted to a different house. You know it,
Yes.
that he has shifted to a different house. Doesn't mean that you will have his land documents also. Correct. So when he's saying that the accused has shifted, I will take it, knowing Mr. FKR Ahmed for so long. We know that he'll say on instructions. He may not have documents.
Definitely, Lordship.
How much time?
When this time, ma'am?
No, not 10 days. We'll give till next Friday, because otherwise we are in vacation. You also file an affidavit to show that you have the land documents. File an affidavit. You said that you have land.
My father's. My father's.
Then your father will have to give a what you will have to produce it on oath. The person who is the owner of the land, who is willing to stand as surety, let that affidavit and documents be filed by them. The person who is willing to give surety. Mr. A.K. Sharma, counsel for the petitioner, Mr. K.K. Parashar, London APP, and Mr. F.K.R. Ahmed, counsel for the informant, are all present. Full stop. On a query of the court, comma, it is not in dispute. The learned APP as well as the learned counsel for the informant have submitted that till date the trial has not commenced. Full stop. It is submitted by the learned counsel for the informant that how many co-accused are responding? Four co-accused after being granted bail in connection with this case. Not this case, it will be the PRC 1118 of 2021 have absconded, which has delayed the trial as P&A proceedings is not yet completed, and for which the trial could not be split up. Full stop. Next, the learned counsel for the petitioner has submitted that till date he is in custody for last 866 days. Full stop. Next, therefore, comma, on the next date of listing. It is also submitted that the family members of the petitioner own land and are ready and willing to offer their own land as surety for grant of bail. Full stop. The statement is objected to by the learned counsel for the informant by stating that the petitioner has already sold off his land at Hojai. As per his instructions, the land is sold at Hojai. Be that as it may, on or before the next date of listing, the petitioner shall file on both the land documents through a land documents by way of an affidavit by a person who is ready and willing to stand as surety. First, the liberty is also granted to the informant to file affidavit to show that the land holding of the petitioner and his family has been sold off. Next list on next Friday is 13.
Sorry, Lordship. My submission was that my family has land, not in my own name, Lordship.
I have not said your name.
Somewhere it is written that I have land.
कुछ नहीं land in his name तो कौन है? No.
Sorry, Lordship. Friday, Lordship.
13:10. Item 36 with 37.
Further them come for admission.
It should have come for admission.
Yes. File by them.
Financial upgradation.
Yes.
You filed your affidavit.
Yes.
In item number
What happened, my lord? Two cases. Affidavit in
item
file.
37, I have filed on behalf of the final department.
Same.
Issue is same, in both cases.
Finance is respond for 2.
Yes. Eight 5150. It is respondent number 8.
Item
37.
Where is the previous order of the court? Where is the previous order of the court?
12/5/2022. The order.
Which page? Which page? The judgment of the judgment of this court. Passed in WBC order dated 21/8/2019 5982.
That is regarding my lord, commutation of pension.
That was your writ petition.
Yes.
So where is that? Where is a copy of that order?
Order my lord,
27.
27.
27. You see, then this part of the claim for 18/5/2010 to 17/5/2011, that has to be rejected. You will not be entitled to that benefit.
Let it come for today. I'm not so much. Let it come for admission.
Okay, both sides are duly represented on the prayer made by Mr. Prakash, the counsel for the petitioner. Matter stands adjourned today. It goes after vacation, that list after ensuing vacation
For admission.
in the admission column.
Item 38.
Yes, health.
Directed to obtain a say each action in this matter. Order dated 30. Private respondent decimal number 4.
Some further time may be given.
Huh?
Some further time may be given.
I have not been able to follow your writ petition. Where is the order? The 125 CRPC. Where is that order?
Let's start from page number 9. And then the relevant portion, page number 15.
She's the wife claiming pension.
My lord,
You obtain instructions.
my lord, I will have that.
Okay.
Private disciplinary member, if your lordship allows for, I can state this private disciplinary member, disciplinary of 4, my mother-in-law. He also applied
Pardon me?
private disciplinary number 4, my.
Huh.
He is my mother-in-law.
Yes.
So, if your lordship allow for, you may take steps on that. Last provision, mother.
Okay.
Statement has been made that the respondent number 4 has also applied. for it.
Yes, yes, that's right.
Earlier did not.
I initially did not follow the repetition. Then I again read it. The line counsel for the petitioner and Mr. B. Goway, standing counsel for the respondent number 1, 2, and 3 present. Full stop. As notice has already been issued by order dated 38/2023, the petitioner is directed to take steps within 2 days for service of notice on the respondent number 4 by registered post with AD. Notice is made returnable. Give a date after 4 weeks. Give 5 weeks after 5 weeks. Returnable on so and so.
1611.
List accordingly. Take steps within 2 days.
Right.
Supply item 46 for orders.
Mr. Goway, you can also get his what do you call this? His documents, whether his her name is there in the pension papers or sorry in the
Yes, that I can, I will.
service record. Just get it
I
there.
have already stated, but
No. He has understood.
On the last, next day, my lord, I will place this.
Okay. On the next date, the standing counsel for the education department shall also produce a copy of the service record of the deceased husband of the petitioner.
It will be
Yes.
department.
Huh?
It will be health department, not education.
Health department. Health department. Yes.
46.
No, 46 I connected to item 33. We already passed orders. 46 is connected with 33.
With that series.
That's it. 46 is connected to item 33.
I think Mr. Khan appeared in the.
So that's why I saw Mr. Khan's name and therefore I saw the cause list.
I'm appearing for the.
Hearing item 41.
Method pertains to non-payment of family pension.
But they're denying your right because in terms of Rule 38, you're not entitled to disable what you call this pension.
But the petitioners, the husband, receive injury pension. It is not specifically mentioned whether under CCS pension rules or extraordinary pension rules. And he already received pension up to his death. After death, while the petitioner approached them stating that the petitioner has not completed 10 years of service. But in extraordinary pension rules, because no need of 10 years of qualified service. Regarding invalid pension also, there is no need of 10 years of qualified service. Applicable for the normal pension.
No, what we have recorded in the order about the Sanic board. So the Accountant General A&E, they are not the competent authorities.
At that point, there is a competent authority, and subsequently, the AG filed affidavit.
No, but we can't give. No, but today we can't pass an order against an authority who's not the competent authority. So what should we do?
Maybe fixed, but AG name is reflected in the cause list.
No, you have not amended your petition. You have not asked for the impleading.
Subsequently impeded.
No, impleading. You see, Accountant General A in Assam has been impleaded. Assam A&E is not the appropriate authority to pay pension for the persons who are in service in border security force. Government of Assam will pay it.
No. At that point, the AG subsequently stated affidavit stated that in the year 1975,
yes,
the AG hand over all files to the AGCR, Central Revenue.
Correct. So your petition will fail for non-joint or necessary party. You must make some prayer.
Now, as per my knowledge, the pension maintained by the BSF,
So you,
by his own office.
no, that's why that has to be implemented. You must make an application and bring it on record.
I have included respondent number 3, my lord, senior accounts officer, pension section.
Number 3 is there.
Here they are, my lord.
Okay, yes. Is there what do you have to say?
That's it. Petitioner husband was not entitled to any pension, lordship. He was wrongly given pension by the Accountant General. By the respondent number 5, lordship, Accountant General. At that time, the Accountant General used to pay pension, lordship, to this person. And from 1976, it was handed over to BSF. So here, since he was getting a pension wrongly, lordship, now his widow, the petitioner, is not entitled to any pension, lordship.
No, but you have not said it is given wrongly.
Wrongly, lordship, in our affidavit, we have stated that it is the Accountant General, they knows on what ground they have given pension to the petitioner's husband.
He was in what post?
The constable.
He was a constable. BSF constable will be entitled to pension.
Lordship, only 9 years, lordship, he has completed his service. 10 years is required to get the pension, lordship.
Which rule? CCS pension rules?
CCS pension rule, lordship, 49.
CCS pension rules.
Qualifying services, 10 years.
CCS pension rules. CCS pension rules. Hey, itu मोटा किताब बताओ. Services manual. नहीं नहीं इमान मोटा किताब है.
So it may another date may fix, let's say.
Center services. इमान मोटा किताब है. itu. Center services. हाँ. बगा किताब है. किस वाले एकदम किस वाले. 49,
Rule 49.
See, 49 is amount of pension.
Hello.
Okay, so he only gets gratuity. He gets only gratuity for that period, not the pension. Yes.
But he has got the pension for his life.
Wrongly granted to him.
Wrongly granted. Now the petitioner, on this ground, the petitioner cannot take family pension.
The petitioner received the husband of the petitioner received the injury pension. That means invalid pension. And it is not a
Under which rule? Under which rule?
under some is book stated in case of invalid pension there is no necessary for 10 years completion of 10 years service.
Where is the document of getting invalid pension?
Yes.
Next affidavit reply additional affidavit of my additional affidavit. Is the authority letter.
No, you will not get. You will not get that pension. This pension additional affidavit.
Additional affidavit.
Page.
Page 11. Additional affidavit. But in stated injury pension.
There is no provision of injury pension.
The husband of the petitioner released due to due to incident due to accident in the year 1972.
No, you see, you are referring to this 44.
44.
stated my lord, that the completion of minimum calling charge of cancer shall not be applicable for grant of.
That is CCS pension rules.
My lord, it is my lord. CCS pension rules, my lord.
CCS pension rules.
My lord. My lord, modified, amended in the year 2021. That's right, my lord.
Please pass that book again then. Just give that book again. Give that book again.
That is mentioned. 39 mentioned invalid pension.
No, no, no. You will not get it. You see, there are two reasons why. Number one, 44 rules has been inserted in 21. Correct. This is referable to rule 39. 39 again is a rule which has been amended, because here it says 39 is relatable to somebody getting invalid pension under the Right of Persons with Disability Act 2016. So 2016 Act was not there when your husband got invalid. In 2000, when did he got invalid?
In the year
1969, he
69.
invalid.
1969. And you see, now you have made a claim at this point of time, whereas in 1980, this what you call, even if there was an invalid pension, that was this 44 was recalled. Correct. So at that point, it was not there. And even today, even if we go by what you are saying, rule 44 read with 39, you still don't get pension. So these are the two reasons.
Another thing, the pension may be granted as per extraordinary pension rules. There is a provision also.
That's it.
You show me that.
For disability
Disability
pension lordship, the percentage of disability has to be assessed by the specially constituted medical board, and on the basis of on the basis of this percentage lordship, this disability pension is given. No, his disability is not assessed lordship by any medical board so as to give any pension or anything like that.
No, you see, now we are examining something of 1969, which is 69 would be 53 years,
And also
54 years.
Even if he is given the disability pension lordship, his wife cannot claim family pension on the ground of disability pension. If this is a personal lordship, on the basis of his disability, it is given. Not a regular service pension.
There is a provision for family pension also. Alternative argument, my lord, as per Assam pension, my lord, there is a relaxation for my lord, qualifying charges, my lord. 67, and in this, my lord, CCS pension rules also there is a rule, my lord, for relaxation. But my lord, the husband already received the pension, my lord, till his death, my lord.
Wrongly given lordship.
The rule 88, my lord, there is a provision for relaxation under the exceptional circumstances.
when completed more than 9 years, below 10 years, less than 1 year. Declared unfit by the medical board, it is reflected, page number 17, of the affidavit opposition filed by the respondent.
But for this, we'll have to give notice to Ms. Devi to respond. This is something which is not there in the petition. And have you mentioned it in the petition? Then you have to amend it. You see, we can't take into account all this.
But I have challenged them into an order, always stated that.
No, because you see, that has been answered. The nature of challenge, now you are modifying your challenge to say that you will also be entitled under the Central Services Extraordinary Pension Rules.
But I stated in the affidavit.
No. You have to amend your petition. Mr. Padgiri, you must understand the volume of files we are handling. Correct. And if you expect that spending my private time at home, I will even read the affidavits and come to court. Is it not something expecting more? No, but then amend your petition. Amending by way of affidavits is unknown to me.
Very old case, there is no mention regarding whether the husband received pension from the CCS pension rules or the is simply stated injury pension. The authorized data.
It's not by the authority.
No. You see that she has answered, and I have followed that. Till you produce this extraordinary pension rules, whatever she has submitted, I have followed it. You see, what has happened is, at that time, at that point of time, some other authority was granting pension. The union government doesn't know about it, and they say that you are under the CCS rules, you are not entitled. And you see, question that whether the rules have been relaxed must appear from the order. Those are not there, whether the rules were relaxed for you. And therefore, if there's a bar for giving pension, not having qualification of 10 years of service, then you're not entitled. And then you were referring to this 44 read with 39. That is not applicable. Now you have come out with this extraordinary pension rules. She must respond to it. She must know what is coming. And without an amendment, we are not expecting the central government to respond. Even if it is old, if you are claiming entitlement under the under this act, they must know it. Once again, Mr. Das, get that book. Mr. Kia Fadgiri, learned counsel for the petitioner, and Ms. R. Devi, learned CCC are present. Next, the learned counsel for the petitioner had submitted that the petitioner would be entitled to pension on account of his of her deceased husband on application of as per the provisions of Rule 44 of the CCS within bracket pension rules, 2021. Full stop. The said contention the court is unable to accept the said contention on account of the fact that this that Rule 44 of CCS within bracket pension bracket close rules was introduced in the year 2021. Stop. Moreover, the under said provision, comma, reference is made to Rule 39 within bracket 9 of the same rules. And there's also a reference to Rule 33, 34, 35, 36, 37, 38, and 39. Rule 39.1 has reference to disability, where provisions of Section 20 of the Rights of Persons with Disabilities Act, 2016 is applicable. First of all, as per the pleadings in the writ petition, the husband of the petitioner was discharged on medical ground on 1/8/1969, and it is not in dispute that he did not have 10 years of qualifying service on 1/8/1969. First, however, the observations are only tentative and not a final verdict of the court on the point. Full stop. Next, at this stage, the learned counsel for the petitioner has placed reliance on the provisions of
Civil service extraordinary pension rules.
Clause 3. Numerical 3, clause 3 of Schedule 2, Roman 2 of CCS within bracket extraordinary pension bracket close rules. Full stop. To become entitled to pension under the said category, comma, the petitioner would have to demonstrate that her husband suffered disability within the meaning of category B and category C of Schedule 2, Roman 2. Full stop. Nonetheless, comma, the foundational facts relating to CCS within bracket extraordinary pension bracket was rules is not pleaded. Full stop. Therefore, comma. In order to put the respondents to notice of entitlement to entitlement pension of the petitioner to disability pension under CCS within bracket extraordinary pension bracket close rules, comma, the petitioner is at liberty to file an appropriate application to amend the writ petition if so advised. Full stop. List immediately after the ensuing. Give a date after puja vacation. List on so and so. Before that, you file it. I'm meeting a set. Other matters will be adjourned.
I'd like to mention item number 54. The petition is going on return on January 2024.
It's a 23 matter. What is the case?
Regarding a suspension, Your Lordship.
Suspension. Who's for forest? You are appealing for forest.
There were two prayers mainly. First was to give him the subsistence allowance, which has already been sanctioned by the Honorable Governor. And the second phase was to timely complete the disciplinary proceedings against him. So Lordship passes a direction to us to complete the disciplinary proceedings in a time-bound manner. The matter can be disposed of. So it has been partly the relief has already been granted.
So how much time you need to complete that?
My Lord, the Supreme Court has set an outer limit of 6 months. But my Lord,
No, but he'll be retiring.
2 years and 6 months elapsed already.
He'll be retiring in January, he says.
my Lord, before January,
Substantial allowance till now we have not received.
my Lord, it has been sanctioned. That's from, I also have a communication. Lordship.
Okay. So then we are not disposing it off, but we are making an observation that the pendency should not be a bar for you to complete start and complete it within the time bound period. For the time being.
Departmental proceedings.
Your Lordship.
Please button up your coat. So we are giving them liberty to do it within 2 months. We are keeping it open since you have not received pension. He says that your pension has been sanctioned. No, not the subsistence law has been sanctioned.
I'm still in service. I'm going to retire in January 2024. I'm going to retire.
It's okay. We are giving them 2 months time to complete it for the timing, and September 23 sanction is there.
Yes.
For subsistence allowance, you might be getting it.
Sanction is regarding subsistence allowance.
That was one of the prayers.
Subsistence allowance.
Mr. Armazunda, counsel for the petitioner, and Mr. A. Barwal, understanding counsel for the forest department.
My Lord, I appear on behalf of Mr. P. N. Goswami.
Learned counsel appearing on behalf of Mr. P. N. Goswami, Additional Advocate General and Standing Counsel for Forest Department. Next paragraph. The case of the petitioner, in brief, is that he has been put under suspension put under deemed suspension under Rule 6 within bracket 2 of the Assam Services within bracket Discipline and Appeal bracket close rules 1964 with effect from 5/10/2020, and he was reinstated in service by order dated 18/5/2022. First off, petitioner claims non-payment of substances and allowance from 1/6/2021 till 18/2/2022.
18.5.
No, you have written 18/2 in your synopsis. I am reading for synopsis.
Or in the prayer, they have said 85.
No, I don't know. You see, we don't have time to read so much.
18.2 is reinstatement.
So after that, you can't have substantial allowance. 18/2.
It's on record.
Full stop. It is also claimed that the disciplinary proceeding against the petitioner has not been brought to its logical conclusion. Next paragraph. At this stage, the learned counsel for the respondents has produced a copy of order bearing number A2. So dated 15/9/2023. And enclosing thereto a copy of the order passed by the government in the Environment and Forest Department, bearing number page 2, number dated 15/9/2023, conveying the sanction of the Governor of Assam for payment of a sum of rupees 8,59,349 as subsistence allowance to the petitioner. First of all, the learned counsel for the petitioner submits that he has not received the petitioner has not received the subsistence allowance. Next paragraph. The learned counsel for the respondents has also submitted that an endeavor is being made to complete the departmental proceeding within a period of 6 months. In this regard, the learned counsel for the petitioner has submitted that the petitioner would be superannuating on 31/1/2024. 31/1. 1st January. It would be
No, you have 31st January.
be sure 31/1/2023, 24. So therefore, it would be in the fitness of things that the respondent authorities should make an endeavor to complete the disciplinary proceeding, disciplinary of the departmental proceedings against the petitioner within preferably within a period of 2 months.
Subject to receiving full cooperation of the petitioner.
However, subject to cooperation from the petitioner. Full stop. Next paragraph. In view, the statement made by the petitioner that substantial allowance not be received by him, the matter is kept pending. list on. After vacation, give a date. Next, in the meanwhile, the respondent authorities shall make an review to complete the disciplinary of the departmental proceeding against the petitioner within 2 months.
Your Lordship, may I
The-
also pray for, there is a provision for penalty, Your Lordship. 2 years subsidy allowance, penalty for that.
Pardon me, I didn't get it.
Regarding the delay in payment of the subsidy allowance, there is also judgment or penalty, Your Lordship. I'll leave
We are
up to
not,
your
we are not
lordship.
invoking
For the
it.
next
We are
day,
not invoking it. The Learned Standing Council for the Learned Council for the respondents shall send a downloaded copy of the order to the competent authorities for doing the needful. The list, the episode of the list of concerns.
all right.